My client's been refusing to meet with me. And I just realized I didn't send over an order to appear, but when I spoke with the Medina County Jail, they advised me that she has been refusing to just meet with anything having to do with CPS. So I can confer with the attorneys in a breakout room. I am going to announce not ready either way because I haven't had contact with her, and none of the contact I've had with her has been productive.
Okay.
But I would be announcing not ready either way.
I think that Irene's idea to meet in a breakout room would be beneficial then.
Okay. We're missing Mr. Saldivar.
I'm here for Mr. Saldivar, Your Honor.
Got it. Thank you. With that, Mr. McKeska, would you please begin the announcements?
Thank you, Judge. Drake McKeska, attorney for the department. Mr. Rod Buckner.
Roland Sherrod Buckner, permanency specialist with the case.
Christy Cannot, permanency supervisor with Belong.
Irene Acosta, attorney ad litem, appointed to represent the mother, Melissa Macias. I'm announcing not ready. And I'm also requesting that a guardian be appointed for Ms. Macias given her questionable capacity, Judge.
Alana Pearsall, attorney for unknown father. I am not ready. And I have filed a report of due diligence with the court that I've just asked the court to take judicial notice of.
Deborah Fuller, I'm standing in for Richard Saldivar, who represents the child, Your Honor. Ready?
Jill Roden, Tri-County CASA.
Jamie Ballou, Tri-County CASA.
Sherry Dye, I represent the intervening grandparents, Armando Macias and Belinda Gutierrez.
We are here for a final trial. After conferring, I did talk to the attorneys and CASA. We've got a looming dismissal date, and there's no motion for any extension. Ms. Acosta has also announced not ready, and Ms. Pearsall has filed her report. So what I want to do is proceed with trial this morning, commence overrule Ms. Acosta is not ready, and then we'll go as far as we can get before our next case, and then we'll reset this for a later date. Ms. Greenlee, probably going to need at least 2 weeks, if not a month, because Ms. Acosta is going to need to do some work along with another attorney. Ms. Acosta, why don't you go ahead and put your request on the record right now?
Your Honor, I'm requesting that either a guardian ad litem or an attorney ad litem be appointed to represent Ms. Macia along with me. There are capacity issues with Ms. Melissa Macias that have potentially gotten worse since the case began, and I want to make sure that that she's adequately represented and that her interests are observed, given that this is a trial and that termination of parental rights are at issue.
All right, so a couple of things. While Ms. Greenlee is looking for a date, she needs to know how much time we're going to need for this trial so she can pick the right date. That's one thing that we did not discuss. When we come back, how much time do you all think would be appropriate?
I would anticipate it being needing at least a couple of hours, given the intervention and the multiple requests for relief.
I would agree, Your Honor, that 2 to 3 hours would probably be a fair assessment.
I would agree, given the number of attorneys, parties, and the number of parties and attorneys and the number of exhibits, Judge.
Well, I'll have Ms. Greenlee looking for a date, and I will at this time address Ms. Acosta's request. I did also discuss this in the breakout room. This court doesn't have the authority to appoint a guardian for an incapacitated party. However, we have in the past appointed an attorney ad litem to work in tandem with any other attorney that might be appointed to assess whether or not a parent is in need of a guardian, and then to work with that parent and pursue procedures through the probate court. So I don't believe Miss Savage has had no affiliation with this case, correct?
No.
No,
Okay.
you're,
I'm going to appoint Kathleen Savage under Texas Family Code Chapter 107 as the attorney to address the capacity issue. Ms. Greenlee, if you could get an email out to her and let her know what we're doing. All right, we've got, let me just take a quick break real quick and consult my calendar with a couple of these different times we have. I'll be right back. I've addressed Ms. Acosta's issue of overruled and not ready. And Mr. McKeska, any other housekeeping issues you have?
No, Judge, I just asked to pre-emit a couple of exhibits. I think it might make things a little faster.
Let's do it.
If you would enable the share screen function, if it hasn't already been enabled, please. Pre-marked as petitioner's exhibit number 10. It is a certified copy of the paternity registry search. Judge, I have been pre-marked as petitioner's 11. I can't remember. Did it change on your screen as well?
It did.
Okay. This is a certified copy of the CCJ letter, also from the Department of State Health Services. And so I just asked that petitioner's 11 be omitted. And Judge, with that, I'd like to call Ms. Sherrod Buckner as my first witness, the permanency specialist that's been assigned to this case.
Yes, sir.
Okay. How long have you been the permanency specialist?
I do believe since June of 2023.
Okay. And whenever you became the permanency specialist assigned to this case, did you review the case file?
Yes, sir.
Okay, so you're familiar with the information contained in the case file?
That I have so far, yes, sir.
Okay. At the beginning of this case, was a Mr. Michael Anthony Ramirez named as an alleged father?
Yes, sir.
And did the department and or belong request genetic testing for Mr. Ramirez?
Yes, sir.
Okay, and was Mr. Ramirez found to be the biological father of Josephine?
He was found not to be the father.
Okay. So the only remaining father that we have in this case is an unknown father. Is that correct?
Yes, sir.
What attempts have you made to be able to identify the identity of the unknown father during the course of this case?
One of them would actually be me trying to attempt to talk to mom to see if she can identify an unknown father. When I did have a conversation with her, she kind of laughed, so I don't think she understood the question. And then I've also spoke to her parents as well, and then they also stated that, they didn't know who could be the father of Josephina.
Okay. Outside of the maternal grandparents and the mother, did you talk to anybody else about who could potentially be the father?
I did speak to her sister. Her name is Cassandra. I did speak to her, and she also was saying to me that she did not know who could be the father of Josephina.
Do you believe that you've made every attempt possible to be able to identify the possible identity of another alleged father?
Yes, sir.
Okay. How old was Josephine whenever she was removed from her mother's care?
She was actually taken at birth. So Miss Macias gave birth in San Antonio, where she was placed in ICU.
Okay. So is it fair to say that she was less than a year old whenever the department was named the temporary managing conservator of Josephine?
Correct.
Okay. Judge, for the purposes of dealing with the unknown father, I would like to pass Ms. Sherrod Buckner.
Mr. Costa?
who else did you interview regarding discovering who the unknown father was?
Just Miss Macias, her parents, her sister. And when I did meet with Mr. Ramirez, I did ask him, which he also said that he wasn't even aware that she, was pregnant when they kind of crossed paths. So he did say that, he did not know either. So those was actually, I do believe, the 4 people that I did speak to. That was it.
And when you spoke to her sister, did she offer any other names?
No, ma'am. According to Miss Cassandra, when I did meet with her, she said that Miss Macias was kind of always wandering off. So when she did kind of come back into the home when she resided with her mother, she was already pregnant at that time, according to Miss Cassandra.
And just to clarify, Ms. Macias never offered any other names aside from Mr. Ramirez?
Not to my knowledge, since I've had the case. That was the only name that was identified.
Okay, and when you went through the case file, let me backtrack. Have you always been the worker on this case?
No, ma'am. I actually got the case back of June of 2023.
Okay, and in reviewing the case file, did any prior workers receive any other names for a potential father?
Not to my knowledge, no, ma'am. I do believe that alleged father was actually named during mediation, I do believe.
Okay, and the grandparents or interveners in this case, have they mentioned anyone that they thought could potentially be the father?
No, ma'am.
Okay, I'll pass the witness, Judge.
Ms. Pearsall.
All the people you interviewed didn't just not give you any possible fathers, but they didn't even have like a first name or, I don't know, a race or any information that could lead to his identity. Is that correct?
Correct.
Now the questions.
Ms. Ms. Dye.
No questions.
Ms. Fuller.
And Ms. Buckner, you feel you've done everything in your power to find this alleged unknown father?
Yes, ma'am, by talking to her family. Yes, ma'am.
Pass witness, Your Honor.
Anything else, Mr. McKeska?
No, Judge. Not this time.
I believe that's sufficient for purposes of commencing trial today. I'll recess at this time. See you all back April 16th, 2024 at 10 a.m. to conclude the trial. Thank you all for your time and your service. All parties are excused.
Thank you.
With that, can we get the announcement starting with Mr. McKeska, please?
Thank you, Judge. Drake McKeska, attorney for the department.
Christy Cannot, permanency supervisor with Belong.
Ona Powell, permanency specialist with Belong.
Deborah Fuller, attorney for the mother, Sharon Grissom. She is attempting to get on, Your Honor, and I'm ready.
Alana Pearsall, standing in for Richard Saldivar for the child, and I'm ready.
Okay, back on November the 11th, Judge Morse was here for me, and she ordered Belong to get some help from some superior authorities to help Lane. There were concerns about the developmental specialist and the neuropsych, and to have a supervisor available at the next hearing if there wasn't somebody to testify. I'm reading from the department's motion to reconsider. I think maybe your client just was Sharon, correct?
Yes, Your Honor.
And then we had a hearing on the 13th in person. Services were not complete. Court asked if there was a supervisor present, and the motion for reconsider.
The last court order. Has there been a developmental specialist assigned to Lane?
We have had difficulty getting that arranged.
That was ordered on August 17th, correct?
Yes, ma'am.
And the mom was ordered to be able to attend those meetings with the developmental specialist?
Yes, ma'am.
And so how come they haven't been set up?
We've just had difficulty between myself and with the help of the RTC of getting a hold of anyone, but we can continue to work on that.
Okay, and you understand that that's a court order.
Yes, ma'am.
Was a neuropsychological evaluation done on Lane?
We've also had an issue getting that taken care of. There's only one in the area that deals with pediatrics.
Okay, it's a court order and that hasn't been completed, correct?
I can continue to work on that.
Okay. And then in regards to your the court ordering that mom be the secondary medical consenter on his form, was that changed?
I believe she's primary, but I can change that as well.
If that's the last consenter that I received, she's not even listed. So has it been changed?
Yes, she's primary consenter with myself as secondary.
Okay. And then in regards to your report, you say that Ms. Grissom needs to participate in individual therapy,
Yes, ma'am.
and she's doing that bi-weekly, correct?
Yes, ma'am.
That she is to do the parenting classes, but that has been an issue that there's been a problem with getting that set up, correct?
Yes, ma'am. And that is out of both myself and Miss Grissom's control.
Okay, so that's no fault of her own. That Belong can do to ensure that these things are getting done. As the joint managing conservator of this child, isn't it Belong's responsibility that these court orders are followed and that this child is getting what he needs?
Yes, ma'am. I can continue to press the service providers.
Okay, and do you think it might be necessary to go above even your supervisor and get a program director or somebody involved to make sure that these things are done?
We can speak with state office to ask for assistance.
Okay, and you understand that when a court orders something, it needs to be done in a timely fashion unless it can't for a verifiable reason.
I do
I will
understand.
say that these cases are the most difficult that we have. And when you have a child with multiple issues, mental health issues, developmental disabilities, I don't know the extent of his diagnosis, but I know that it's very difficult. And I think everybody's trying to do the best they can. I will find that the mother is in compliance with the plan of service and doing what she needs to do. It looks like the only thing that was ordered by the court was the counseling and the parenting. And, those parenting classes are difficult to come by that would be appropriate. I don't want her just taking some random parenting class. So, I do think that at this point, I'm going to continue all the court's orders in this case, but I do think it would be appropriate to get, your management at Belong involved in this. I don't know how the structure works there for sure, but get somebody higher up to try to help facilitate this. I've had a few other cases where we've had really hard to place older children, and frequently people from the administration have appeared at the hearings and are aware and trying to help get these services done. So I think that it's appropriate to reach out to them to help facilitate, particularly if he's going to have to be moved. That's going to be a challenge, and then he's going to have to start over at whatever his next placement is. And I do also think that you need to make sure that your administration knows that he's been ordered to have a developmental specialist and a neuropsych eval. I don't know what the holdup with those are, but they need to figure out how to get that done. And that's that's not me, that's a prior court order that needs to be done. And these developmental specialists, I don't know how many are available there, but they need to be on all the cases that are like this. I do think also it's important to note that because it is a joint managing conservatorship case, that the mother and Ms. Fuller, as well as Mr. Saldivar, need to, receive all documentation.
Your Honor, can I ask one thing? If the neuropsych and the developmental specialists are not assigned or not done prior to the next hearing, I would ask that you order someone from Belong who is higher up, I don't know who that would be, appear before the court and testify why this is not happening. This was a court order 3 months ago.
Right. I think that's a good idea, and that kind of gets you off the hook. I know that Ms. Powell, you don't have a lot of control over that, but your superiors and Ms. Conop's superiors need to know that this is important. You can't just not follow a court order. So if that's not done, then I think somebody from the administration of Belong needs to be present, or somebody from state office with DFPS needs to be present to explain why that's not feasible.
And I would also ask that the death benefits be returned to Ms. Grissom so she can see her child.
I don't know if that's within the department's purview, because that's through the Social Security Department, and they, if the child's not in the home, I don't think they're going to send him the money. The money is for him. So, I agree with your concern, but on the other hand, I don't know that that's within the department's purview. I think they were
able to do it on another case, Your Honor.
Okay, well, I think they can follow up with it. I'm not going to order that because I'm not sure what it can be done, but I think it'd probably be a really good idea to have somebody else higher up from Belong or with the department to appear at that hearing. Even if some of these issues are addressed, it's not a bad idea. So,
motion for reconsideration argues that Ms. Conop answered in the negative based on a misunderstanding about whether there was a different supervisor present, which there was not. So the court assessed 2 fines against Belong that day. One, I'm going to read my notes. So, one for not having that person present as ordered, and then also the court ordered to have the neuropsych scheduled within 10 days at the facility, and if it wasn't scheduled, will be a fine of $100 a day assessed. The only thing set for reconsideration today is the $100 fine for not having the supervisor present. I do want to bring it to the party's attention that there was a record created of Judge Morris's hearing. Have you all seen it?
I have not.
I have, Your Honor.
Okay. Well, the record essentially, I want to make sure that Mr. McKeska has an opportunity to review it. But I'm going to allow the department to urge their motion. And you don't have to repeat everything I said, Mr. McCusker. I think we're all aware of it. Just argue the specific points and allow Ms. Pearsall and Ms. Fuller time to respond. And then in the meantime, I'm going to forward you, Mr. McCusker, the email I just received this morning of that record from the November 11th hearing.
And Your Honor, two other things. You said you only assessed a fine on the neuropsych. You also assessed $100 a day for the developmental specialist. And the motion for reconsideration says that they're also asking the hearing for the current status as to the services. So I would hope we can address all of that today.
We will, and I was just sort of simplifying the issues based on the department's motion. I know there's an order that's got more specific language in it. All right, I'm currently sending Ms. Fuller, Mr. McCusker, and Ms. Pearsall the ruling that I just received this morning from Ms. Greenwald, which is a portion of Judge Morris's ruling from November the 11th, 2023. So you should have it. With that, Mr. McCusker, if you'd like to make your arguments.
Sure, Judge. I did base my arguments based off of the written order that was in the file. So, Judge, I really want to start with kind of an overview of a court's authority to issue sanctions against a party. Anytime a court issues sanctions against a party, it does invoke due process issues for the party that it's issuing sanctions against. And essentially, there's two different types of sanctions that can be issued, one for criminal contempt and one for civil contempt. For criminal contempt, usually that's some sort of punishment, right? Punishment for violation of the order, which I think the fine that was assessed back on the 13th falls into that category. Because it was a violation of or a perceived violation of the order. And so the fine was issued against Belong and the department for that. For civil contempt, the party the court is issuing sanctions against essentially holds the keys to the jail. And is typically used in situations where a court will order a person to do something in the middle of a hearing, like to answer a question. They refuse to do it. They will put them in jail until they answer the question, right? They hold the keys to the jail. At any point, they can answer the question. They can get themselves out of the sanction that is designed to spur the compliance with the order. Like I said, sanctions evoke due process issues for any party. And so the procedural aspect for that to occur is usually that there's going to be some sort of motion that's filed. Then there's a personal service on the party of that motion, and then the court holds a hearing. Those procedural steps weren't followed in this case, and so I would argue,
Your Honor, I would object to him arguing about those other fines. That's not what we were here. They only did the motion to consider for that $100 fine, which is clearly, I mean, a lot of attorneys have had to spend time getting ready for a hearing that was really pointless because the transcript clearly says that someone higher up had to be a part of the hearing, not Ms. Knopf. It's very clear on page 4 of the transcript.
Well,
so I'm glad Mr.
Finish making my introduction. Right. I think that all of this information is vitally important because it comes down to courts, jurisdictions, and authorities to be able to issue, whether it's the $100 fine for someone not being there or the prospective fine of $100 per day. All of these issues are invoked whenever a court issues sanctions against the party. And so,
let me ask you this question. Are you distinguishing these from direct contempt?
Well, so for indirect contempt is a violation that would have occurred outside of the courtroom versus direct contempt, which happens in the court's presence, right? Directly in front of the judge.
So you're arguing that the supervisor not being present as ordered is indirect contempt rather than direct contempt?
Well, I would argue that even for the direct contempt, there still has to be specific findings. There still has to be specific orders, those sorts of things, in order for the court to be able to make that finding. So if I can I'll fast forward then, that for a court to be able to issue a contempt fine against court, number one, there has to be a reasonably specific order, right? It can't be ambiguous. It can't be unambiguous. If the court looks back at the written order that was signed, that becomes the official order of the court. I understand that the transcript may read differently. I haven't had the opportunity to view that yet, but the order that was signed by the court said that a supervisor must be present to be able to discuss the issues. Number two, there has to be a violation of that reasonably specific order. And then number three, there has to be a finding that the violation of that order was actually willful. It can't just be negligence. There actually has to be an intent to violate the order in order for the court to sanction a party. And then because it's a punishment, right, that has to be beyond the findings, the evidence has to be beyond reasonable doubt. So in this case, I would argue that the department and Belong did not willfully violate the court's order. And the order that's being referred to, again, if you look at the written order that was signed by the court and becomes the official order of the court, it's a two-part order, right? They were ordered to schedule the appointment for the developmental specialist and the neuropsych evaluation before the next hearing. And then if those appointments hadn't been set up, to have a supervisor present to testify. So if we look at the first part of the order, the Belong actually complied with the order. And I can elicit testimony to support this, but for the developmental specialist, for the neuropsychological evaluation, Belong actually had an appointment scheduled on January 30th of 2024, right? That was after the November hearing, is before the February hearing. So they complied with that portion of the order. They had the appointment set up. Now, the child didn't get to go to that appointment because his placement changed on January 29th. It was a child-specific contract for an out-of-state placement that required placement on the 29th. As soon as the prior placement found out that placement was going to be changed, they canceled the appointment on the 29th, on the 30th for the neuropsychological evaluation because they set it up, then they canceled it. Right? Child was then placed in Arkansas. And there were attempts that were made in Arkansas to be able to set up that neuropsychological. Again, the testimony, I can elicit testimony regarding the difficulties the current placement has had, even hiring their own internal neuropsychologists to be able to do these evaluations. So I'd argue that the department complied with that portion, or Belong complied with that portion of the order. As far as the portion of the order with the developmental specialists, there were attempts that were made to comply with that order, but there were complications and speed bumps of getting that appointment scheduled between the time the order was issued in November and the hearing that was held in February. Specifically, the child's placement changed 5 different times. He was documented on runaway status 7 different times. And in order for the department to be able to get the appointment with the developmental specialist, it requires a referral from the PCP. Well, every time the child's placement changed, the PCP changed, right? And so all of those things led up to them not being able to schedule that appointment. So I think the department did comply with that first portion of the order. With regard to the second portion of the order, again, I think the order has to be reasonably specific. The written order says a supervisor must be present. Ms. Knopp was present. If it was supposed to be a program director, if it was supposed to be higher than a program director, the written order should have reflected that it was supposed to be someone above Ms. Knopp and not just a supervisor for Belong.
Let me stop you for a second. Miss Greenlee, that's an order that Judge Morris rendered and signed. Can you send it to me, please? Because I don't have it.
I'll look for it.
I can't find it. You can continue, Mr. McKesson.
So like I said, I think that that Belong complied with that order as well, because Ms. Knopp was available at the hearing on the 13th in order to be able to testify as to the difficulties with setting up both of those services.
He did. I remember it.
Your Honor.
Go ahead,
Mr.
Ms. Fuller.
Mr. McKessa has a few of his facts incorrect, but again, he wasn't the attorney on the case. So the original order was actually August 15th at the status hearing, and that's when you ordered the neuropsych and you ordered the developmental specialist. That was the original order. This child was in the same placement from June till November. He was not in 5 different placements. From June till November, he was in the same placement. It was ordered in August. In November, we came back to court, and as the transcript says, Judge Morris specifically said, if it's not done, then somebody from the administration of Belong needs to be present, or somebody from state office with DFPS needs to be present to explain why that's not feasible. And she was very clear about someone higher up than Ms. Knopp. And the fact that they're saying Ms. Knopp, she said, no, I spoke to Ms. Knopp a few days before the hearing and specifically asked her if someone was going to be present from Belong. And she said no. So she knew that was a requirement. I asked her about it. You know, as far as those other orders, there's been children on other cases of mine in Houston that have had neuropsychs within 30 days, you know, in the same area that this young man was in. And you ordered them to do the neuropsych in August, then Judge Morris ordered it again in November, and then you ordered it again in February. To this day, there's been no neuropsych. There's been no developmental specialist assigned. When Mr. McKeska says, well, the caseworker decided to cancel it, she didn't bring him that exact day. She could have taken him to that appointment. She chose to cancel it when it took months for her to actually finally find somebody, and then she chose to cancel it, even though she knew it was ordered in August. She knew it was ordered in November. And to this date, I received a report from the department saying he has one scheduled April 1st in Austin. And then the very next day, I receive an email. He has one scheduled for March 26th in Dallas. So I don't even know what is going on here. And in the report that was filed with the court on February 27th, she also says there still hasn't been a developmental specialist. And she came up with something about an anticipated wait list of 18 to 24 months. That's the first time I've ever heard that. It's just another excuse not to do what the court has ordered. The court was very specific in August. The court was even more specific in November. And then come February, when you finally issued the fines, it's because they're not following your court order. This child has not had either one of those done yet. And I don't even know if I know the developmental specialist, as far as the last report we have, that's not even set up. You know, they're saying they have to go through his PCP, but all the other caseworkers I've talked to said they go through Superior Health and they get it set up, you know, and that's how it's done. And they can get it done within a month to 6 weeks. And we're talking months now, obviously, since August. I think it was August 15th when you first ordered it. So not only does the $100 fine for someone from Belong Administration or DFPS state office should stand in place, the fact that these other services have not been set up, just based on and I'm not a math major, just the developmental specialist, the fine is already up to $2,500. And because I can't determine what the actual day is that they've set up the neuropsych, it's $100 a day from whenever that is, so this is a total disregard of your order. Again, Mr. McKeska said, that they were moving his placement and the caseworker decided to cancel the appointment. Why would you ever cancel an appointment that took you 6-7 months to get? I'm sorry, and if they're saying it's because he went to Arkansas, the report said they were going to be taking him to Dallas or Austin for these tests. So why wouldn't they just take him back for the appointment from Arkansas if that's where they're going to be taking him anyway? I can't tell because the emails and the report are totally different. So I don't even know if it's actually set up. So, this is so frustrating to me that this child has not had his needs met. These were things that were so specific to him, and they weren't done. And they continued not to follow your order. They continued not to follow Judge Morris's order. And then today we're here arguing about a $100 fine because Ms. Knopp said, no, there's not a supervisor here. That is completely ridiculous. That wasn't the basis of your order. It was someone above Ms. Knopp. And these other, the other arguments of Mr. McKeska, it's pointless to say that you cannot have issue these fines when it's been set up 3 hearings. They very specific. This is what you need to do. These are they've been on notice. This is what you need to do. This is who you have to bring, and that there will be consequences. And so today to say we just need to,
not even worry about it is totally ridiculous. Someone needs to be held responsible for this total lack of commitment to this child. To just, I mean, and I would ask that you fully enforce those fines. Again, my last count, it's at least 2,500 for the developmental specialist because it hasn't been set up. And who knows how much for the neuropsych, just because I don't know if it's even been set up, because there's two different reports that don't even make sense. And so I'm asking you as the court to enforce your ruling and make them responsible for what you've ordered since August 15th of 2023.
Thank you, Ms. Fuller. Ms. Pearsall.
Judge, Mr. Saldivar doesn't have a strong opinion on this matter. So I think he's deferring to the court as to what the court sees best. I will tell you so there is a judge in Bexar County who's been mandamused a million times. And I've responded to 90% of those mandamuses. So I am for years now. So I absolutely can tell you the court has the authority to sanction the department. And it's been upheld by the fourth court that they have an inherent right to sanction the department with some limits. They have found that exorbitant sanctions will not be allowed. So for example, she issued a sanction of $2,500 per day. And that was struck down. But, you know, as far as the child's ad litem, he feels that the court has the wisdom to rule on that issue on his own.
Mr. McCaskey, any rebuttal?
Yes, sir. So nowhere in my argument did I say the court cannot order sanctions against the department. I agree 100% the court has the authority to do so. However, when the court is going to exercise that authority, the due process rights of the party that it's issuing the sanction against have to be recognized. And that's what I'm asking the court to do, right? And the reconsideration is, in order for a court to be able to issue those sanctions, there has to be a motion, there has to be personal service, there has to be a hearing. A lot of the cases that were referenced out of Bexar County have dealt specifically with those issues, and the mandamuses have been upheld. Those orders were struck down. In order for then, during that hearing, before the court can issue the sanction, it has to be proved that A, there is a reasonably specific order, B, there is a violation of that order, C, that the violation was willful, right? And that they intended to violate the order. They wanted to violate the order. Then there's various defenses that can be asserted during that hearing, like the impossibility defense, which is part of what I brought up in my argument earlier. So what I'm asking the court to do is to reconsider those fines. If the court and Ms. Fuller wants to hold the department accountable, then she needs to follow those steps in order to ensure that the due process rights of the department are being recognized. And
well, let me break in real quick, just because I want to make sure that we don't go too long on this. It's not lost on me that there's a distinction between direct and indirect contempt. And it's not lost on me that there's a distinction between civil and criminal, and the due process rights of the parties are not lost on me either. In order for a court sua sponte to take action, as I did in this case, because I mean, I'll just make it very clear to the parties, I am unhappy that we're still sitting here talking about this. And if I need to start from scratch and figure out the correct way, although I don't necessarily know for a fact that I'm outside of my authority at this point, but we can check into that. There will be consequences for this, because I feel like, as Ms. Fuller pointed out, since August, these things have been in place. And in November, Judge Morris said, if you can't do it yourself, get help. It's in the record. And if you don't get help, then have somebody here at the next hearing to tell the court why it can't be done. And Ms. Fuller's right. None of those things happened. Not one of them. And if there's impossibility, okay, I can understand that. But if Ms. Fuller's allegation that Ms. Powell had appointments scheduled and then canceled them, after it took so long to get one, that's not impossibility. That's just a bad decision. And it's at Lane's expense. And so we're here today, and I don't fault you at all for protecting your client and doing your job, Mr. McKeska. I'm not saying anything about that, but I feel like all of this is a distraction. I feel like I am being put in a situation where I'm essentially powerless to enforce my order because if it's seen as indirect contempt, then no, it's not. I can't do it the way I did it, and I have to redo it, and I will. But that's a distraction. And that's more time spent. We're going to come back again, and I'll get it done. But I don't think that that's helping Lane. I fined Belong because I wanted this to get done. And apparently that fine didn't do what it was supposed to do, because we're still here over a month later and we're still not done with this. We still don't have it done. And I'm unhappy. So I'm going to take this under advisement. I'm going to go do my own research. I'll let the parties know something by Thursday as far as what I'm going to do. What I suggest that Belong does in the meantime is you find a way. You figure it out. And then we'll have a follow-up hearing based on what I decide in my research I need to do. I'll get with all parties. I'll get with Ms. Greenlee, and I'll let you know when it's going to be. But, I feel like in all of these cases, I'm very understanding of when we have an impossibility situation. I'm very understanding of when we've got normal delays. This is beyond all of that. And
Your Honor, the motion to reconsider was only on the $100 fine. Didn't mention the other ones.
I understand. I'm going to take a look at everything because I want to give everybody the attention this deserves now that I've heard the arguments. I read the motion back on the day I got it, but I'm only hearing the arguments today. And so I feel like it's only fair to everyone for me to do my diligence and make sure that there's not an I haven't dotted or a T I haven't crossed, and to find out if there's any case law that supports the decision I made that requires me to go back through the process. And if Mr. McKeska is right, then I'm going to do that because this needs to get done. And Belong needs to understand that I'm not going to stop until it gets done. So that'll be my order for now, is that I'm taking it under advisement, and I'll get back with you. All right. Thank you for your time and your service. I do appreciate your arguments, Mr. McKeska.
Thank you.
Ms. Fuller, Ms. Pearsall. All parties are excused. With that, Ms. Kyler Green, would you please begin the announcements?
Emily Kyler Green, attorney for the department.
Christy Knott, permanency supervisor with Belong.
Ontropolis, permanency specialist with Belong.
Deborah Fuller, attorney for Ms. Grisham. Sharon Grissom, the mother. Could you please unmute and announce Ms. Grisham?
Sharon Grissom, mother of Lane.
There we go.
Sorry.
It's all right.
Katie Stout, here on behalf of Richard Saldivar for the child, present and ready.
Director for SJRC Belong.
All right, we're here for final trial. Department or Belong has a motion to retain under 263-401B on file. I'm still working on some of the other issues that we were here for last time from a procedural perspective. So we're looking at a dismissal date of June the 24th right now. Ms. Kyler Green, just give me a brief synopsis of what the department's going for here.
Yeah, Sean, the department's asking for an extension in this case due to the fact that Lane right now is in somewhat of a new placement and is, I guess, in the stages of acclimating. And so we put feelers out to the parties to see if everyone agreed with the request for an extension to give him more time and to be able to achieve any sort of permanency for this case.
Okay. And did you encounter any opposition?
I did not.
All right. Ms. Fuller, what are your thoughts?
Your Honor, I think an extension is necessary so Belong can do their job. To be honest, I haven't seen a neuropsych. I haven't seen anything about a developmental specialist. My client has not been provided with parenting that meets the needs of her child. And so I think it's necessary for them to be able to do their job. And so this child can get the help he needs. My client's been doing everything that she needs to do. And she hasn't been provided the services for herself or for her child throughout the case.
Ms. Stout, did Mr. Saldivar give you any notes?
Yes, Your Honor, he did, and he is in agreement with an extension. Your Honor?
Yes.
Okay, I just wanted to make sure you can hear me. Yes, he is in agreement with an extension. He believes that that the child needs more time given the new placement.
Thank you.
Your Honor, but I would like orders in place. Not that they're going to be followed, but I would like them in place if we're going to do an extension.
No, I object to the sidebar comments.
Sustained. What requests do you have, Ms. Fuller, that I haven't ordered already?
Well, most of it's been ordered already. Obviously, the family counseling, the parenting for my client, the developmental specialist. I don't know if the neuropsych was done, never received anything on it. So I'm not sure if that was even done. So those are the most important things. Obviously, there was an issue with Social Security. There's some money that Belong says they never received. My client didn't receive it from October until March. And so someone needs to find out where that money is. That's been asked over and over, and there's no answers about that money either.
Ms. Kyla Green, let's put on a little evidence through Ms. Powell of extraordinary circumstances, please.
Yes, Your Honor, thank you. Ms. Powell, can you unmute, please? Okay, so I know that you've presented to the court your efforts and Lane's status right now. Could you please talk about where Lane is currently placed?
Lane is currently placed in Arkansas at Mill Creek Behavioral Health.
And how long has he been there?
He has been there since the end of January.
Okay. And what sort of obstacles have you encountered in providing services or dealing with resources for a child who's placed out of state?
The main hurdle was trying to get services that are covered by his insurance. That was one of the hurdles. And logistics, getting him back to Texas for his neuropsych and other appointments.
So then let's talk about the neuropsychological exam. What is the status of that?
We are awaiting results. So the neuropsych was performed on March 26th in Arlington, Texas. So we're waiting. They said it would be about 2 weeks for us to get that report back. So I believe we're rounding out 2 weeks. So we're waiting as well.
Okay. Okay. What other services for Lane are you waiting to either ascertain or to see if insurance is going to cover?
We're having difficulty getting the developmental specialist because Lane is simply too old. We've been referred back to neuropsych due to his age and developmental stage. So we've spoken to quite a few, and he is too old and he doesn't have a diagnosis, a developmental diagnosis. So we've been continually referred back to neuropsychology.
This is specifically for the fetal alcohol syndrome?
Yes, they say that they can't test for it.
Because this is something that either should have or would have been tested as an infant, but since it wasn't done, no doctor is going to do it at this age. Is that what you're being told?
Correct.
Okay. And so instead, you're being referred back to neuropsychology, which has been completed.
Correct.
Okay. In terms of the placement that he's at, what sort of services is he receiving from the placement itself?
He's receiving his individual therapy. They're also, he and his mother are receiving family counseling. That's a part of the program there. So last I knew, I believe they're up to 2 sessions they've had, 2 or 3, one in person, I believe, when she visited him. He is receiving his medication regularly. And I asked that they incorporate grief counseling, and I believe that they're slowly trying to incorporate that when he's comfortable.
When you talk about the family counseling between the mother and Lane, is this also incorporating, to your knowledge, counseling specifically for a child such as Lane to help Ms. Grissom better parent?
To my knowledge, it is just that. And it's also helping them get along better. It's focusing on their relationship and repairing their relationship.
Okay. In regards to the specific parenting classes that have been ordered, what is Belong able to find for that?
At this time, we haven't found a parenting class that solely speaks to the issues with Lane and his mother. We did send out a referral for Chosen, but I was told that that would be something better suited for when Lane is back in the home. Then Chosen can kick in with those parenting classes. It right now looks like it's the best bet for us and the circumstances of the case. So it would have to happen after Lane is returned home.
Okay. And are there potentially other services that the placement's going to provide for him once the neuropsych is back?
Yes, ma'am. I believe that they're going to continue. I believe Ms. Nanette said some type of family counseling virtually, I believe is what they're telling me, but they're still working his plan. Well, his plan for himself at the placement is worked out. They're still working those logistics out when he's returned home.
Okay.
And they do believe that.
Hang on just a second. I wanted to make sure. Okay, Mr. Salazar, you let Ms. Stout know she could go. Okay, continue, please.
Thank you, Your Honor.
Yes, Judge, I'm sorry.
So these services that are pending and the results of the neuropsych, are those, do you feel that it is in Lane's best interest for the court to extend this case in order to allow those results to come back, and then for Belong and the resident experts to decide what further services, if any, are needed for him? Okay. So is that why you're requesting the court extend the case?
Yes.
Is it safe at this point in time to return Lane home to his mother?
No, it is not.
Okay. Thank you, Your Honor. Nothing further.
Ms. Fuller.
Ms. Powell, how long have you been on the case?
Since August.
And so today you're saying that now Lane is too old for a developmental specialist. You were ordered to get one back in August. I've never heard this excuse before. When did you come up with this?
This is what I've been told by the service providers I reached out to.
And that's just recently. Now all of a sudden he's too old.
Yes, that is what I'm being told.
And you say he has no diagnosis, but he does have diagnosis, doesn't he? What's he diagnosed with?
Not a developmental diagnosis. His current diagnosis is bipolar and ADHD. He doesn't have a developmental diagnosis.
So the parenting classes were supposed to focus on his issues, the bipolar, the ADHD. The parenting classes were supposed to focus on that. So you're saying that there's no parenting classes out there that focus on bipolar children or children with ADHD. Is that what you're saying?
Not teenage children. The best one that we found would be Chosen.
Okay.
But
and again, you said that the parenting class was supposed to be focusing on the issues between Lane and his mother. That's not what the court ordered back in August. It was a parenting class to focus on Lane's diagnosis, wasn't it?
Yes, it was. And none of those parenting classes spoke directly to his ADHD or the problems in the home.
And the grief counseling, that was recommended in the very beginning back in August as well. So that hasn't started at all, the grief counseling.
I do apologize. I'm sorry. They have attempted in the other placements to incorporate grief counseling. And even in the present placement, they said they're letting Lane go at his own pace regarding grief when he wants to talk about the death of his father. He is not ready at this time.
And have you provided my office with any notes regarding any of these counseling sessions that you say have occurred?
Mill Creek will not release those notes to us. They're also a behavioral hospital.
And so you need a court order to order a placement to provide notes on a child that's in their care?
That's what it looks like, because they are also a behavioral hospital.
And so are you going to be asking the court today to order that?
I can.
Okay. And in regards to the family counseling, this is the first time there's been family counseling as well, right?
Yes, it is. It's a part of the treatment program.
Okay. And so you have to ask for a court to order that as well?
That's correct.
And my client goes and visits her son. How are those visits going?
From what I understand, the visits were going well between she and Lane.
And do you have any notes in regards to those?
I have the notes from when speaking to Lane and his mother.
So basically anything in regard to this child and his services, or my client and any services that she's accessing through this placement, it has to be court ordered.
Any notes having to do with his therapy?
And how often have you been to Arkansas besides the time you placed him?
I was in Arkansas for 3 days, from March 25th through March 27th, and I'll be returning to Arkansas tomorrow.
Well, you said you were in Arlington on the 26th, so you weren't in Arkansas, were
We
you?
flew-
You said Arlington.
We flew to Dallas from Arkansas, then flew back to return Lane.
Okay. Does anyone else check up on this child when you're not available?
Other than his mother and his attorney, his mother and his attorney.
So there's no one else that can provide any input on what is going on in Arkansas except when you go once a month?
Or when I reach out to them, I reach out via email and they will send school records. The only records we're unable to get are the records having to do with his therapy.
And have you provided all those records that you are able to get to my office?
I have what I have, I've provided.
Pass the witness, Your Honor.
Mr. Salvador?
Overall, how is Lane doing in this his new replacement?
He says that he likes the placement and he's doing much better than I've seen in other placements.
Okay. We don't have the constant running away at this placement, is that correct?
He attempted once and it was only once, but no, he is not running.
Okay. And has he addressed that one time attempting to run away with his counselor?
Yes, he has. And they put him on runaway protocol. And yes, it was addressed with his counselor.
Okay. Did he explain to you why he did that?
Initially, he said he didn't want to be there. So he devised a plan with another resident. They didn't get very far. They didn't get off the property. He's acclimated now. He better understands the program now.
Okay. And would you say that continuing this placement is in his best interest at this time?
Yes, it is.
Okay. And his goal is to move back with his mother. Is that correct?
Yes, it is.
Okay. And the therapist is aware of his goal and his desires. Is that correct?
Yes, she is.
Okay. And to your knowledge, has she discussed with Lane what she wants to see from him to get that accomplished?
To the best of my knowledge, she has.
Okay. And will the court order from this case work in Arkansas to release the records, to your knowledge?
To my knowledge, I'm not sure, but I can try.
Okay. And other than the records order, are you asking for any other orders from this court?
Not at this time.
Okay. And how is Lane doing school-wise? Is he up to date?
Yes, he still hasn't done his credit recovery. They don't offer that until the summertime, but Lane is getting C's and B's. So he's doing much better. He says that he likes the classes because they're smaller classes than in public high school. So he surprised me when he told me he's enjoying school there.
Okay. Any other concerns that you have at this time for him?
Not at this time.
Pass the witness.
All right. Ms. Carla Green, do you have anything else?
No, sir.
Ms. Fuller?
No, Your Honor, I just ask that you order that the records, it's odd to me that he's been placed over 2 months and they're not able to get any records and they're fine with that. I mean, if I would have known that's what we were waiting on, we could have had a hearing and had you order that we get the record. That just doesn't make sense to me at all. So I'd like for you to order that the placement turn over those records. I mean, that's my client's child and she's entitled to those records. I want them to look at it. And I'm sorry, I mean, this case has really aggravated me because there are definitely classes, parenting classes for children with ADHD and bipolar. I mean, those things are, I mean, he's had those diagnoses. We've had the order for months. And so I'm not understanding that. Now we're just going to wait and do parenting classes whenever he goes home. Doesn't make sense to me, Your Honor. The grief counseling, I think, is very important. I think that this is the first time I'm hearing he's too old for a developmental specialist. So I kind of question that as well, because we've been going along for 8 months. If that was the reason, I would assume that someone would have brought it up in court before. So I'm very concerned that we're not getting the full story here and that I'm not getting the information that my client needs and she's not getting the services that she needs. I mean, It sounds like her son is doing so much better in this placement. And to me, the extension is necessary for him to finish that program because he is doing well. But these other services were just as important.
All right. Mr. Saldivar, is there anything that you want to add as far as the headline report?
Judge, I would ask that his placement continue, and I believe that it's in his best interest to finish this program. He is doing a lot better. You can hear it in his voice. You can hear it in his attitude that he's doing a lot better where he's at. He has some bumps along the road. We did talk about his trying to leave, and staff kind of set him straight on that. And they instead of getting mad at him, they're telling him that they encourage him to do better because they know that he can do better. And I think he's starting to realize that his actions have consequences. And I think therapy is going well. And so I do want the court order for the records, Judge. Hopefully that'll work, and Mill Creek will give us those records because I think it's important to know that how he's doing with the progress. But overall, he's doing well where he's at now. And he does want to go back home to Texas. He does want to go back home with his mom. And he's asking for a hoodie because I think some of the kids took his hoodie. So if we can get him a hoodie as soon as possible, that'd be great.
All right. Thank you. Okay, for the purposes of the final trial, court finds that all parties received notice of the department's motion to retain, and all parties have agreed. Court finds that after hearing the evidence, extraordinary circumstances necessitate the child remaining in the temporary managed conservatorship of the department, and continuing the appointment of the department as temporary managed conservator is in the best interest of the child. Court will retain the suit for a period not to exceed 180 days. New trial date is going to be, new dismissal date is going to be December 21st, 2024. It's December 21st, 2024. Next permanency hearing is going to be July 9th, 2024 at 9 a.m. July 9th, 2024 at 9 a.m. Final trial will be October the 8th, 2024 at 10. October 8th, 2024 at 10. I will order that services that I have previously ordered be done. If it hasn't been done yet, like the grief counseling, things of that nature that were brought up in this hearing. I've already ordered them before. I'm not going to go through the whole list again. You know what they are. We're going to extend this case, and he's in this placement and it's working. Get this stuff done. I'm going to order that his therapy notes be disclosed to all parties immediately. If Mill Creek gives you a problem with that, Ms. Powell, I need to know about it post haste. So they tell you we're not going to do it. I need to know. I don't want to wait to find out. I want to know immediately. I'm going to order Belong to get Lane a new hoodie. Now, there's another lingering issue. I'm glad to hear the neuropsych was done. I'm looking forward to everybody getting those results, including myself. I'm glad that was done. We had a hearing previously on a motion to reconsider, and I told everybody that I would let you know what was going to happen with that. I did some research. I made some calls, and I needed to see what we were going to do today to find out what sort of jurisdiction I was going to have over this case, because we're not done with that yet. I want to make sure that we don't slow down in our tempo of this case from this point forward. And so that's still in the works. And I want to make sure that as we move forward, I don't want to be punitive in this case. I want to keep a fire lit. Like I said last time, all these sanctions, everything, that is not what I enjoy doing at all. But it took getting to that point for this neuropsych to finally get done. And if that's what it's going to take to get us through this case, then that's what we're going to do. It's not what I want to do at all. I did receive an affidavit from Ms. Powell with some supporting documentation that does explain a lot, but it's still, we're extending this case because it's taken so long to get us to this point. I know it's not all the responsibility of one single person, but I also realize that this is the framework in which we have to operate. And I don't want Lane to suffer for any delay that could be prevented. And so we're gonna keep moving, and I'm gonna keep pressure on. We're gonna keep going with this process that I started. I'm glad to hear that we've got some progress. I'm glad to hear that he's doing okay in the placement. I just want to know that we're going to continue this tempo of getting things done quickly rather than waiting months to do it. So that'll be the order of the court. Obviously, the trial's reset. We extended the case. I will be circulating my new setting for the motion to reconsider as soon as I can take a look at the calendar. I needed to know what we were going to do today, and then I'll get that out. Thank you all for your time and your service. If nothing further, all parties are excused.
Thank you.
You're not allowed to do that during the court.
Please refrain from direct communication. This is a court heading. This is a court setting.
For 51st Judicial District Court of Kendall County, Texas. Mr. McKeska, would you please begin the announcements?
Drake McKeska, attorney for the department. Mr. Rabago.
Cynthia Rabago, caseworker.
Carol McCata, family-based supervisor.
Lucinda Mance for the mother, Melissa Gallimore. Miss Gallimore, if you could please announce. I'm ready.
I'm ready.
Deborah Fuller for Kevin Rodriguez. Mr. Rodriguez, could you please announce?
I'm ready.
You need to state your names, please.
Oh, Kevin Rodriguez.
Thank you. Ms. Gallimore, if you could please state your name.
Melissa Gallimore.
Thank you.
And Your Honor, Marco Cabrera, Mr. Richard Zaldifar is the attorney ad litem. I'm here on his behalf. Ready.
Thank you.
Amy Harding, Hill Country Casa supervisor, guardian ad litem for the child.
We are here for an adversary hearing. The parties have had some time to confer. How do you wish to proceed, Mr. McKeska?
Judge, it's my understanding that we do have an agreement with regard to Mr. Rodriguez. However, we do not have an agreement with regard to Ms. Gallimore. So we would need to have a hearing with regard to her.
Okay, well, let's get started then.
Judge, may I just, I guess, present the terms of the agreement with Mr. Rodriguez to take care of him?
Yes.
So Judge, Mr. Rodriguez is the alleged father, and it's my understanding he's agreeing to the department being named as the temporary managing conservator. He is asking that he complete genetic testing in order to determine whether or not he's the biological father of the child. We are asking if he is adjudicated as the father to waive medical support, child support. We are asking a family group conference to develop a family plan of service. And Ms. Fuller, is there anything that I forgot?
I just wanted to add that he will be at the Dominguez unit in San Antonio probably later this week, and he'll be there for a few months. So the DNA testing, if they can set it up at the Dominguez unit. And then if he's the father, if they do the testing before we come back to court, he would also like the weekly supervised visitation if he is the father.
All right. Is that the entire agreement, Mr. McKeska?
Yes, Judge.
Ms. Fuller, is that your understanding?
Yes, Your Honor.
And Ms. Mance, I know you're not privy to this agreement. Mr. Cabrera, is that the agreement you understood as to the father?
Yes, Your Honor, and I agree.
Casa?
That's my understanding of the agreement with the alleged father, sir, and that I agree with it.
You believe it's in the child's best interest?
I do believe it's in the child's best interest at this time.
Okay. Ms. Robago, you heard the agreement?
Yes.
You believe it's in the best interest of the child?
Yes, Judge.
Mr. Rodriguez?
Yes, sir.
You heard the terms of the agreement?
Yes, sir.
Did you make that agreement voluntarily?
Yes, sir.
Were you forced in any way to agree to it or made any promises to get you to agree to it?
No, sir.
Do you understand it?
Yes, sir.
Did you have a chance to discuss it with your attorney?
Yes, sir.
Are you asking the court to approve your agreement?
Yes, sir.
Thank you, sir.
Yes, sir.
Anything that you wanted to add or Mr. Saldivar wanted to add, Mr. Cabrera?
No, Your Honor.
Okay. And Mr. Rodriguez was served, the court will take judicial notice, he was served, I have March 15th, 2024. Mr. McKeska, do you have anything else?
No, Judge, I believe that's correct.
Okay. And based on the agreement of the parties, the announcements of the parties, court will find that Mr. Rodriguez was duly cited and served as far as this adversary hearing is concerned on March the 15th, 2024. Court finds that the parties have agreed as to Mr. Rodriguez only for the department to be named temporary managing conservator of the child pertaining to Mr. Rodriguez. Finds that the parties have agreed that Mr. Rodriguez will complete genetic testing, and if he is adjudicated as the father, the parties have agreed to waive medical support and child support. Court finds the parties have also agreed to participate in a family group conference to develop a family plan of service for Mr. Rodriguez, and at that time come up with the services that the parties will present to the court. I will also make a finding that Ms. Fuller has represented to the court that Mr. Rodriguez will be at the Dominguez unit for a few months beginning this week. So Mr. Robago, whoever's taking this over, we need to make sure they know that we can get that DNA test set up pretty quick. Then it may be possible to get him tested easier than if he gets moved again.
Yes.
Yes, Your Honor, he'll be there until June, and then he'll be paroled to his brother-in-law's house, but he will be there until at least June.
Okay.
I'm not getting on parole again.
Okay,
yes,
I'm sorry.
Yeah.
Then he'll be released in June.
Okay. Then that will be the agreement as to the father, and the court will make orders accordingly. As to the mother, we still have the issue of whether or not the court will award temporary managing conservatorship of the child on the mother's behalf to the department. Do you have any housekeeping issues you need to take up at this time, Mr. McKeska?
No, Judge.
All right. Miss Gallimore has her hand raised. Miss Gallimore, what, you don't need to have your hand raised?
No, I was itching.
No, it's raised on the computer. You see that little hand signal?
I don't remember. I don't know what hand signal you're talking about.
It's on your screen. I'm going to lower it. Just want to make sure
Oh,
you
I
don't have
don't-
a concern.
Oh, I'm sorry. I'm sorry. No, sir.
It's all right. Okay, Mr. McKeska, let's proceed, please.
Thank you, Judge. Judge, I'd like to call Ms. Gallimore as my first witness.
All right, Miss Gallimore, she's been sworn and has taken the oath, and you may proceed.
And how are you related to Bryson?
It's my son.
Okay, Ms.
His
Gallimore,
mother.
where are you currently residing?
I am currently at Ripple Ranch Recovery
Okay,
in Spring Branch, Texas.
okay. And when did you enter treatment at Ripple Ranch?
Sunday in the morning at 1 o'clock.
And that was this past Sunday?
Yes, sir.
And was that, you said in the morning, was that 1 a.m.?
Yes, sir.
Okay, prior to entering treatment at Ripple Ranch, when was the last time you used methamphetamine?
The night of the night before.
Okay, so if you entered on Sunday, would that be on Saturday night?
Yes, sir.
Okay.
They said I had to.
Who said you had to?
My insurance, because they wouldn't have been able to admit me. They wouldn't have been able to claim it as against my insurance due to the fact that if I was clean, they wouldn't have saw it necessary for me to seek recovery.
Okay, so Because your insurance company told you to use methamphetamine to get treatment, you decided to use?
Well, I mean, that's the only way I could have gone and entered into, the only claim that, they said that they will only claim it because of the insurance. I mean, I've heard it, I mean, 1,000 times, but I didn't really believe it, but I just did it, yeah. To get the insurance picked up on it. It's the claim. That's how they go by. Some insurances are different.
Okay. Prior to entering Ripple Ranch, were you in treatment somewhere else?
Yes.
Okay, and where were you in treatment?
At New Choices in San
Okay.
Antonio, Texas.
And when did you enter treatment at New Choices?
I don't really recall. I mean, I know it's about a couple of weeks ago, maybe.
Okay, and how long were you at New Choices?
1 week and 1 day.
And why did you leave New Choices?
I was administrative discharged on false allegations.
Okay. How long between your discharge from New Choices until you entered treatment at Ripple Ranch?
A week.
Okay, and
Or not even a week. Yeah, about a week. The week.
Okay, and during that week,
I was trying to find other recovery centers that would take my insurance and then also get with me. The one I found was in it was Stonegate Center Recovery, and it was located on the outside of Fort Worth, Texas. The only thing is I had to get there, and I was trying to figure out how I could get there without paying $1,000 out of pocket to get there. And then till the last minute, I said, I found this place. And it was like right up the street. So all I had to do was get a ride from my mom.
okay. So prior or after you were discharged from New Choices and in that week period where you were between treatment centers, how many times did you use methamphetamine?
Twice.
Okay.
Because because of the
Hang
only
on,
reason why I
Ms.
used.
Gallimore. Ms. Gallimore, when you get asked a question, just answer whatever question is asked. So he asked you how many times, you said twice. That's where your answer stops. Because if you add more information every time, we're going to be here a lot longer than we need to be here. And you might give information that wasn't requested. Okay. So just answer the question that you're asked and answer it very concisely, please. Go ahead, Mr. McCaskill.
Thank you, Judge. Ms. Gallimore, prior to entering treatment at Ripple Ranch, how often would you use methamphetamine?
Let's repeat that again.
Yeah.
Repeat that again.
Prior to entering treatment, right, at New Choices, how often would you use methamphetamine?
I don't understand the question.
How many times per week would you use methamphetamine before you went to treatment at New Choices?
Oh, how many times per week? I don't remember I don't even know how to answer that.
Did you use daily?
No.
Did you use every other day?
No. Every other day, like maybe like once.
You'd use methamphetamine once a week?
I mean, like, yeah, if I needed to, yeah.
Okay. And whenever you would use, how much would you use?
Less than $5 worth.
When did you start working with the department to address the concerns for your drug use?
I mean, I don't know the exact date.
And can you give me an approximate time frame?
When I spilled the beans, is that what you're asking me?
Well, when did you start working with CPS to engage in services to be able to address these concerns?
I don't know the exact date. I don't even know the time frame.
Okay, how long has Bryson been placed with your parents?
I'm gonna say 6 months ago. approximately.
When's the last time you saw him?
About 2 months ago.
And do you recall this court ordering you to complete services with the department?
Yes, sir.
Okay, and do you remember what services you were supposed to complete?
Yes and no. Like a little bit.
Okay, what services do you remember?
A psychiatric evaluation, a drug, I think it was a drug and something like that. A drug assessment, and there was one more, but I don't remember it. I think. Pretty sure. I don't know.
Okay. Were you supposed to complete random drug testing?
Yes, that too. Yeah.
Do you recall when the court ordered you to complete those services?
No, sir.
Okay. Did you ever complete the psychiatric or psychological assessment?
No, no, I did not, sir.
Okay, did you ever complete the drug assessment?
No, sir. It was in making, but it never happened. My phone was so.
Okay, but do you recall the court ordering you to either enter inpatient treatment or get on a waiting list for inpatient treatment?
Yes, I remember that. Hold on, ask that again.
Yeah, do you recall the court ordering you to either enter inpatient treatment or get on a waiting list for inpatient treatment?
Yes, I do.
Okay, do you recall the court ordering you to get on that list or enter treatment within a week?
Yes, I do.
Okay, and did you enter treatment within that 7-day period?
No, sir, I did not.
Okay, did you submit to the request for random drug testing?
Yes.
And were you using methamphetamine during the course of those court orders?
Like, can you specify? I don't know what you're talking about.
Yeah, sure. So after the court ordered you to complete these services, were you still using methamphetamine?
What services?
The services that we just discussed. After the court ordered you to complete those things, were you still using meth?
After the whole being told that I have to go into a treatment facility, or the other things?
From the date the court ordered you to complete services with the department, were you still using meth?
I don't remember. I'm sorry.
Okay.
I don't remember.
Ms. Gallimore, have you entered treatment before?
Yes,
How many times have you attended treatment before?
at least 5 times.
When was the last time you completed treatment?
I believe it was the last thing I remember, and I don't know if this is accurate, but I think it was Charlie's place. In 2011, I believe. But oh no, I'm sorry, my bad. It was I know that's the last place like in treatment that I went to. I also went to outpatient. Does that count?
Okay, so whenever you said that you've done treatment at least 5 times, was that inpatient and outpatient combined?
Yes.
Okay. And so when's the last time you completed a substance abuse treatment program?
That was in 2019. I believe. I'm not for sure. It's around that date, around that year. And that was at Haven for Hope for IOP.
And you haven't had any treatment in the last 3 to 4 years?
No, sir.
Okay. When did you first start using methamphetamine?
When I was about 24.
How old are you now?
40.
Did you ever care for Bryson while you're under the influence of methamphetamine?
No, sir.
Where would Bryson go, or where would he be whenever you used?
With my mom.
Okay. Whenever you would use, how long would you be actively under the influence?
A day or two.
How long would you wait until you would go pick Bryson up from your mom's house?
48 hours before I go pick him up. Or he'd come and return back to me. Or sometimes 3 days.
Okay. Did you use while you were pregnant?
No, I did not actually. I didn't even smoke cigarettes.
Did you receive prenatal care?
Yes.
Were you drug tested?
Yes.
Did your OBGYN know that you had a history of substance abuse?
Off and on, yes. She knew. She knew everything about me.
Pass on instruction.
Ms. Mance?
Yes, Ms. Gallimore, what attempts did you make during the 7-day time period that the judge gave you to go or enroll inpatient?
The attempts that I made, I called various many places and tried to get either on a waiting list or inside of a bed. I mean, trying to get a bed, but I mean, I was also waiting for them to reach out to me. And my phone at the time, I do apologize, but my phone at the time I was on Wi-Fi. I didn't have an actual phone service, so picking up Wi-Fi and then holding a conversation and like not being per se dropped, the call dropped or anything like that. I'd have to like it was hard. It was like difficult. That's why I ended up anyways, that's why. But it wasn't like I wasn't trying or anything. It was just I was really like me trying to live out there and just actually find somewhere that's not anywhere around people using and like trying to collaborate, playing a game plan, trying to get me into rehab myself, without anybody's help but myself. Trying to find I don't know what to say. It's just, that's all I have to say.
So your testimony is you were making efforts every day to go inpatient.
Yes, I was.
And when you were discharged from the initial place, what efforts did you make from that time period to Sunday?
I changed my place where I was staying at. Instead of a hotels, I went and pretty much put myself in a place that I knew people weren't using or doing anything. It was crazy and hectic over there, but they weren't using. So I was still doing the same thing. I was still on the phone with people, I guess out of San Antonio, because I was trying to find somewhere. Maybe it's like not trying to find somewhere close by, but just trying to find somebody. Because how do I say it? Like the first place I went to, I learned a couple of things, like change your people, places, and things. So that's what I was going off of. I was trying to change my place of environment. So maybe instead of San Antonio, somewhere outside of San Antonio. And then I was trying to locate different places. Places that I called, they said that they didn't have beds available, that they didn't even have a waiting list. So I'd have to just keep calling every day. And that's how I tried. Like I just kept on pursuing, one foot in front of the other, trying to make an initiative to get somewhere like within a reasonable time. And I was trying to go for the place up in Fort Worth, that place up in Fort Worth. But the only thing is getting there. It was like nobody had the money to take me, nobody had the car to take me. I was kind of like and then if not, I mean, like it was just the timing and I think I talked to Cynthia on the Friday. She said she was gonna take me up there, but I'd have to wait till sometime on Wednesday or close to Wednesday to give her a heads up. And that was like already like, that's like 6 days away. I didn't want to wait that far. Like, I just wanted to go. Like, all I wanted to do was
Ms.
go.
Mance, we need to break this up. This is kind of a rambling narrative. So, Ms. Gallimore, I'm going to remind you again, just answer the specific question that you're asked and wait for the next question.
So, Ms. Gallimore, do you believe that you were in compliance with the judge's order?
In compliance?
By either entering or attempting to get on a wait list for a
Yes.
rehab facility. Now,
Yes.
when you would place your child with your mother, do you believe your child's safety was ever in jeopardy?
No.
And what efforts have you made since you've been at the current inpatient? And what strides have you made?
I don't know what that means. What strides?
Well, when you and I were talking, you told me how you feel like you're going to be successful where you are. What efforts are you putting forth?
Getting up every day and going to class.
Are you fully engaged?
Yes, I'm fully engaged. I want to be.
And you're abiding by all the rules?
Yes, ma'am.
So are you asking the court to deny this motion and allow you to go back to court-ordered family-based services?
Yes, ma'am.
And you'll comply 100%?
110%.
All right. Thank you. I'll pass, Judge.
Ms. Fuller.
Ms. Gallimore, you were served with the paperwork, correct?
Yes, ma'am.
Okay.
I think.
So the original allegations were that your child was living in a home that had roaches and dog feces and trash throughout the house and no electricity. Was that true?
It didn't become. No,
It's just a yes or no. Was it true that that was what your home was like in July?
In July
of last summer?
In July? I don't remember. In July, I don't remember.
So you don't remember living in a home with no electricity and roaches and dog?
Yeah, there was no electricity and dog feces. I didn't have a dog.
Okay. And at that time, did they try to get you to engage in services?
I don't remember the date. I don't.
Okay.
I'd have to look back on my calendar.
So you had a family-based safety services case in September of 2023. You remember that?
No, I don't.
Judge,
Okay.
I'm going to object because I think this is all ground that's been covered in the proffer.
Response.
I'll move on, Your Honor. Let's go back a little further. Ms. Gallimore, how many children have you had removed?
And Judge, I'm going to object. I don't know the relevancy of this.
I mean, it's relevant, Your Honor, because Ms. Mance wants the court to believe that someone who's been in inpatient treatment for 2 days since Sunday should go back to court-ordered services when she has a history with the department for numerous years, according to the affidavit, like
Objection's
over 10 years.
overruled. It's overruled. You can continue.
So, Ms. Gallimore, how many children have you lost through the department?
Lost?
That you lost custody of?
One. Or no, I mean, one. Lost custody.
Do you have any of your... I'm sorry. Go ahead.
I gave my mom and my dad custody because that's not losing. That's me giving my daughter life because I mentally couldn't take care of her.
And when was that?
When she was around 2.
I mean, what year was that?
I don't remember.
Okay. But you had other children removed also in 2014?
No. 2014?
Yeah. What about Tyler, Elizabeth, and Emerson?
Tyler wasn't my son.
Okay. So you weren't involved in the department in 2014. Okay.
I was, but that was something to do with not from me, like per se. I mean, it was because my ex-husband was choking me outside in the front yard because of his Xanax. I mean, like that had nothing to do with me. It eventually had something to do with me because I freaked out.
But those are your children.
Elizabeth and Emerson, yes.
Okay.
But they weren't removed. They still had custody of them.
But you don't have any of your children at this point.
And?
No, she asked you.
It's a question.
She's asking you a question.
Oh, okay. But
repeat your question, Ms. Fuller.
You don't have any of your children at this point in your life.
No. Or Bryson?
Okay, you answered the question. You said no. Go ahead, Ms. Fuller.
And Ms. Gallimore, you already testified that you've been using meth for the last 16 years, since you were 24 years old. Why would you think the court should go back to a court-ordered services case? What do you think's different to where you shouldn't be involved in a regular legal case?
I'm human. I mean, we all make mistakes. I'm not like, I've done it before. I've succeeded before. I'm a go-getter. Like, I'm just not gonna like give up on my son. But I don't think that I don't think it should, I don't think it's fair. I really don't. That's my son. He needs me.
And you also
I'm a great
testified
mom.
that
Hang on, Ms. Gallimore.
Ms.
You've
Gallimore,
answered
you
the
also
question.
I'm sorry, you
That's okay.
You also testified that you would leave your son 2 or 3 days at a time so you could go get high. Do you think that's good parenting?
I didn't say that. I mean, I misunderstood the question, and that's why I don't understand some of the questions you'll ask, but that's not what I said, 2 to 3 days at a time. That's not what
Judge,
was.
I am going to object because I think that was a mischaracterization of her testimony.
Why don't you rephrase your question, Ms. Fuller? Sustained.
What I had written down was you said that you were gone 2 to 3 days while you were using and your child was left with your mom. So you didn't say that. Okay.
I didn't, that's not what I meant.
Okay. What is different this time, Ms. Gallimore? You've had over 10 years of involvement with CPS. What's different?
Well, I mean, whether or not judge told me that he told me that I needed to go and do this, it was still a choice for me. And I chose to do this. It's not, he didn't tell me to do it or else. He just told me this is your choice. You know, if I, at that moment in time, if I didn't choose to, if I didn't want better, then I would have chose to come this way.
But actually, he ordered you to do these things back on December 13th of 2023 in a court-ordered services case. So you were actually ordered to do these things.
But even though at that point, yeah, you're right. You're right. And at that time, I still could have chose whether or not I wanted to or not. You know, I mean, I chose to. I want different. I'm tired of that lifestyle. I'm tired of. I'm sick and tired of it. Actually, I'm very sick and tired of it. But if I still at that moment had a choice.
I'll pass the witness, Your Honor.
Mr. Cabrera.
Thank you, Your Honor. Ms. Gilmore, what are you asking the court for today? Are you asking for your child back?
Yes, I am.
Okay. Do you have a job right now? Are you employed?
Not at this moment. No, because I was trying to get into rehab. No.
Do you have a home right now?
Not in my name, no.
Okay. And it's your testimony that the last time you used was a few days ago?
Yes, sir.
Okay. And you still feel that it's in his best interest to be with you?
I mean, of course, but I mean, right now, I would be comfortable with keeping him at my mom's house of right now until I get help and treatment, until I feel comfortable enough to, yes. I mean, it is my son. It's my responsibility.
Those were essentially the terms of the motion to participate plan for the prior case for court-ordered services, correct?
I don't know what you're saying. I'm so confused.
Before we were here, the prior case was what they call an MTP, correct? Where the judge ordered you to do these services, right?
Right. Mm-hmm.
Okay. And so what you're saying is that what you would have liked is to do it the way it was, right?
Yes, sir.
Under that type of, but you were successful then, correct?
Well, no, I wasn't.
Did you complete your rehab?
Excuse me?
Did you complete your rehab?
I just started.
So this new rehab, this is the first one you're in?
Second one.
Judge, I'm just
Okay.
going to object because we're all asking and she's answering this very same questions that each person has asked her. It's very repetitive.
I think Mr. Cabrera is trying to make the point that mom is asking for her child back today and for the court not to remove. And I think you've established, Mr. Cabrera, what you were seeking to establish.
Your Honor,
go ahead.
I apologize for the interruption. I have one more question,
okay,
and then I'll be done.
All right.
Ms. Gallimore, if the judge grants CPS custody of your child, is it your intention to remain in rehab?
Yes, sir.
Okay, that's all I had. Thank you. I'll pass, Your Honor.
Any follow-up, Mr. McKeska?
No, Your Honor.
Any other questions for this witness?
No, Your Honor.
All right. Any other witnesses,
Yeah.
Mr. McKeska?
Judge, I'd like comments for Bago.
All right. She's been sworn. Let's take about 5 minutes real quick. I've been sitting here for a while. So before we start with her, let's take a 5-minute recess. It's 12:25. We'll be back at 12:30.
Mr. Rodriguez, you're not allowed to do that.
Sorry.
How are you currently employed?
I'm employed by the Department of Child Protective Services
Okay, in what capacity are you employed by the department?
as a caseworker.
Okay, for family-based safety services?
Yes.
Okay. How long have you been working with Miss Gallimore?
Since October, the end of October 2023.
Okay, and was there a prior FBSS worker that was assigned to her case?
Yes, sir.
Okay, and who was that caseworker?
Jennifer Simmons.
Okay. When did Family Base receive this or receive the investigation to offer ongoing services to Miss Gallimore?
September 25th, 2023.
Okay, so you became the caseworker approximately a month after the case had commenced?
Yes.
Okay. During the initial stages of the family-based program or family-based case, what services was the department asking Miss Gallimore to complete?
To complete a drug and alcohol assessment, random drug testing. I believe she was also asked to complete a psychological and domestic violence counseling and treatment.
Okay. And the department filed a petition for court order participation services. When was Ms. Gallimore ordered to complete services?
That was on December 13th, 2023.
Okay, so between September and December, did Ms. Gallimore voluntarily engage in any of the services being requested by Family Based?
She did not.
Was she being asked to complete drug testing?
She was.
Was she completing those tests as requested?
She was not.
Did you have any
Ms. Gallimore,
discussions?
You can't react to everything Ms. Ravago says. Stop shaking your head. Go ahead, Mr. McKeska.
Thank you, Judge. Did you talk to Ms. Gallimore about why she didn't complete drug testing?
I did.
Okay, and what did she disclose to you?
There was often different answers. She didn't want to either focus on it or she didn't. There was just a lot of reasons.
Okay. Did she ever admit to you that she used controlled substances?
She didn't. Yes, she did. There's just several times throughout the case she did, but yes.
Okay. So after the excuse me, after the court ordered Ms. Gallimore to complete those services, did she engage in any of them?
After the court order, she did get herself into a sober living home in San Antonio, and they were drug testing her there as a requirement to stay there, and she was testing negative in January for them.
How long was she in the sober living home?
I believe it was 20 something days, give or take.
Why did she leave the sober living home?
She stated to me that she just was on her way home one day and just didn't go home, and she just started walking. And then she did not get there at curfew. So she was asked to leave.
After she left the sober living home, were you able to maintain contact with her?
No, I did not. No.
Can you give me the approximate date she was asked to leave the sober living home?
I believe that was, sorry, I don't have it right in front of me. January, it was around January 20 something. And then I believe I found out that she left on January 7th when I was trying to arrange a visit with her. I'm sorry, February 7th.
Did Ms. Gallimore disclose to you what she did in that interim period?
She did.
Okay, what did she disclose to you?
That she met random people on the street that she was staying with. And she had to, when we're talking about her substance use and her relapse, it took her a minute to admit that she did have a relapse. And she stated that the people she was hanging around with, she had to use in order to prove that, she wasn't a snitch.
What attempts did you make at that point to help Ms. Gallimore get into a substance treatment program?
And I'm sorry, what time period are we talking about before or after the court?
Yeah, this time period from whenever you met with her or spoke with her on February 7th.
Okay. February 7th, at that point, I was trying to just get her engaged in meeting with me. We were trying to explore whether or not she had experienced a relapse. I did ask her, if she was safe and where she was staying. I did send her for a drug screen on, did I just said her? What month are we in? On February 12th, I asked her to go do one. She did go to the facility. And once she learned that it was a hair test along with a UA, she was disruptive to the facility, refused to test. The facility, I spoke with the manager. They said she was throwing things, tore up her paper, and walked
Judge,
out.
I'm going to object because she's now getting into hearsay.
I'll sustain that. Just keep it to what you actually observed or what she told you directly, Ms. Rabaglia. Thank you.
Yes, Judge.
When we attended court on February 14th, do you recall what the orders of the court were that day?
Yes, for her to, she was court ordered to get into treatment within 7 days of that hearing.
Okay. Was there a second part to that order? Do you recall?
Oh, or be on a list. I apologize.
Okay. What attempts did you make to help Ms. Gallimore get into treatment after February 14th?
Right after the hearing on the 14th, I immediately called her to inform her that I wanted to go ahead and start the process of locating a bed for her. She answered and stated she has no idea why I'm calling her, that she had the judge's orders and she knew what she needed to do and she had 7 days to get it done. I provided her, or I went ahead and made contact with Craig Lambria at San Antonio Council Drug and Alcohol Abuse because they're work really fast with us. And I know they're willing to, do assessments over the phone quickly. I gave him all of her contact information. He immediately started contacting her that day to get the process going. Contacted her the following day, and I believe 2 days after that still, and she would not return his calls. On the 15th, I sent her a text message letting her know that we still needed to meet and that Mr. Lambry was trying to get a hold of her and he would be able to get her into a place quickly. I also sent her links to Journey Recovery because they have the ability to have mother and children together. I also sent her information for Volunteers of America, and I called them as well and left her information.
Okay. At any point during that 7 day period after the 14th, were you able to secure a bed for Ms. Gallimore?
I was not. She did not want to go to Alpha Home with Journey, so she did end up having a phone call with Craig. I believe it was on the last day or the day after. I'd have to look back. He was going to recommend her for alpha. And then on this day, we learned that she had insurance, private insurance. So because she had private insurance, we weren't able to get her a state bed. They had to go through that. I obtained the insurance information from her mother. And then that's how she was able to get accepted into New Choices.
When were you able to confirm that she was able to enter treatment at New Choices?
I believe she went in on the 23rd, and I confirmed with them on Monday, the 26th of February.
Okay. Was she able to secure a bed by the 21st?
No.
Okay. But she entered treatment, at least according to the affidavit, on the 22nd, the evening of the 22nd. Is that correct?
That's correct.
Okay. How long was she at New Choices?
For a week. She was asked to leave on March 1st.
Okay. And when did she notify you that she was discharged?
March 4th at 3 p.m.
Okay. And then according to Ms. Gallimore's testimony, she entered treatment at Ripple Ranch this past Sunday, which was the 17th. Is that correct?
Correct.
So she was out of treatment for approximately 16 days?
Correct.
During that time frame, did you have any contact with Ms. Gallimore?
Text message.
Okay. When did the department file the petition to remove Bryson? Do you recall?
March 7th.
Okay. So during that interim time, and specifically after March 7th, were you making efforts to engage Ms. Gallimore in services?
Yes.
Okay. And what attempts were you making?
I would call her, text message her, same thing, try to get in front of her to meet with her in person.
Okay. And was she responsive to those requests?
She would respond to me periodically, but would not meet with me.
Okay. Pass it, Josh.
Ms. Nance?
Yes. So what I'm hearing is once the department learned she had insurance, then the inquiry had to be started over because she had to use her insurance first, correct?
No.
So when was the department notified that she had to go through her insurance?
Craig was the one who assessed her. I'm sorry, and I lost my date in front of me. The day he assessed her is the day we learned she had insurance, and he was able to get her that day into New Choices. So there was no discontinue of the process.
But she willingly went to New Choices and she willingly went to Ripple Ranch, correct?
Correct.
And she's been engaged with Ripple Ranch, to your knowledge?
I have no knowledge of that.
Now, the child during this entire time period, and actually even when it was family-based, the child has resided with the maternal grandmother.
Correct.
So the child's safety has never been in jeopardy, correct?
Correct.
Mother's never tried to take the child, run off?
She has not.
All right, thank you. I'll pass, Judge.
Ms. Fuller?
Mr. Bago, in regards to the grandparents, they don't have any legal custody of this child, correct?
Correct.
There's no legal documents that allow them to make decisions regarding this child.
Melissa did sign a caregiver authorization form that we had notarized. Other than that, no.
But legal forms in regards to a custody arrangement?
None.
So Ms. Gallimore can show up at their house at any time and pick up her child anytime she wants?
Yes.
And you heard her earlier testimony that she wants her baby back today. So do you feel like the child would be in danger if the court did not grant this temporary managing conservatorship to the department?
Yes.
And do you think the department had any other alternatives but to file this emergency removal based on the circumstances involving Ms. Gallimore and the child?
No. We've exhausted all efforts.
I'll pass the witness, Yar.
Mr. Cabrera?
I have no questions, Judge.
Any follow-up, Mr. McCusker?
No, Your Honor.
Any other cross for Ms. Ravago?
No, Your Honor.
Next witness, Mr. McCusker.
Judge, with that, the department rests.
Does anybody else have a witness to call during their case?
No, Your
No,
Honor.
Your Honor.
All right, let's go ahead and start with argument. Department, please.
Thank you, Judge. Judge, the department is requesting that it be named as temporary managing conservator Bryson, and that Ms. Gallimore be named as temporary possessory conservator. I think that, Ms. Gallimore's extended history and more specifically the history that she's demonstrated in front of this court and with this court shows that it's been a struggle to maintain her sobriety and provide for her child Bryson. During her testimony, she stated that Bryson's been placed with her parents for about 6 months. She hasn't had any contact with him for about 2 months. Based on that, and the fact that she's has essentially abandoned him with her parents, and has continued to use, has entered treatment, been unsuccessfully discharged from treatment, was out for approximately 16 days, and then readmitted to treatment. I mean, it just shows that there's a level of instability here that simply is not safe for Bryson, and that level of instability does in fact present an immediate danger to Bryson, as Ms. Fuller drew out in testimony just moments ago. There's nothing that would prevent Ms. Gallimore from going and picking up Bryson from her parents' care, and exposing him to that overall life of instability. I believe that it's in his best interest that he be removed and placed in the department's temporary managing conservatorship. Asking the court to order the parties to attend a family group to develop the family plan of service. Even though there is an agreement, I would ask the court to waive the child support medical support at this time, especially while Ms. Gallimore's in treatment. I think that's fantastic. She's in treatment. I want to see her be successfully discharged from that treatment. And so I wouldn't want there to be any sort of burden as far as child support medical support to be heaped on her while she's involved in that process. Bryson is 2, and due to the lack of contact over the last 6 months, Judge, we would ask that the visitation be planned twice a month for an hour, supervised by the department. I would also ask the court to authorize the parties to be able to increase that visitation schedule based on mom's compliance and her and the agreement of the parties. I think that we need to recognize a parent's ability to make changes in these cases and to give them something to work towards. And so I would ask the court to give us that flexibility to be able to do that. If the court were to grant the parties or the department today, I would ask that it adopt and approve the agreement that we reached with the father earlier today.
Thank you, Mr. McCusker. Ms. Mance.
Judge, I do not believe the department has met their burden. There is no immediate danger to the child's physical health or safety. The child has been at the maternal grandmother's home consistently. Mother has never made any attempt to remove from that child from that home. In fact, her testimony was that during periods that she would use, she would take the child there because that was a safe place. So I don't think that the department has met that burden. Additionally, the order was that she either enter inpatient within 7 days, make attempts, be on a wait list. She did make attempts. She wasn't there within 7 days, but she was there shortly after. She was discharged, but she got back on board and turned herself back in to Ripple Ranch, and she's really giving it her all. So I'm asking that she be allowed to go back to court, family-based services. Again, I do not believe there's been one shred of evidence, testimony that this child is in any immediate danger. If the child were, the department should have called the maternal grandmother. They didn't. I don't think there's anything there. The child is perfectly safe where he is. Additionally, Judge, the alleged father is currently incarcerated, but for some reason he's going to get 1 hour a week visits. But a mom that's not incarcerated and that has admitted herself into treatment, the department's asked for 2 times a month. I think that's punitive because she made a decision to actually contest this rather than reach an agreement. So I'm asking that if the court does grant the 262 hearing motion, that she also get a minimum of 1 hour per week and that it be supervised at her parents' home as long as they are in agreement with that. Thank you.
Thank you, Ms. Fuller, actually, excuse me.
Your Honor, I would ask that you accept the agreement of my client, Mr. Rodriguez, and order the DNA testing to be done as soon as possible at the Dominguez unit, and then he will engage in services if he's determined to be the father. We're hoping that Ms. Gallimore, and he's hoping that Ms. Gallimore will be able to get clean and sober. I mean, this is a start, but it's only 2 days, and by her own testimony, she said she wanted her child back. She wanted her child back now. And when Mr. Cabrera asked her the question, she said she wanted him back now. So that's the danger when you have someone who's has this long a history with substance abuse and this many treatment options and, you know, failed inpatient and outpatient. That's the danger to this child, because she's saying she wants him back. There's no legal recourse at this point if she goes and picks up this baby. And so that's the danger, Your Honor. But I would ask that you accept my client's agreement with the department and do the DNA, the family group conference, and then the weekly supervised visitation if he's established as the father.
Mr. Cabrera.
Your Honor, Mr. Saldivar has met with the grandparents and the child. They're doing well there. He's been there for a while. He started Head Start and is doing good. I do see benefit in TMC in getting him assessed developmentally, given what sounds to be a long-term exposure. As for visitation, you know, the issue with twice a month visitation wasn't to be punitive. It's because of her history of not showing to visits. I don't have a problem with more frequent visits with mom, but I think the concern is should she show. I do have a problem with being supervised by grandparents, just because, you know, she has testified to active current drug use. Because of that, I think it's important to have those visits supervised by the department.
Thank you, Mr. Cabrera. Ms. Harding.
Thank you, Judge. At this time, CASA does not believe that the mother is in a position, or that either parent, frankly, is in a position to provide this child with a safe, stable, drug-free, violence-free home. I do hear that Ms. Gallimore is engaged in treatment at this time, and I do hear that she wants to do different and make better choices to get her son back. And I think that the best way for Bryson to be protected during this process while mom gets her stuff in order is to leave him in the temporary managing conservatorship of the department and in placement with his grandparents, so that mom can focus on getting herself stable and sober. She has a long history of substance abuse. She has a long history of engagement in services and very limited history of sobriety, is what I'm hearing today. I think it is in the child's best interest that he stay with his grandparents. I would appreciate the court considering asking mom to submit to a hair drug test if a hair drug test has not been completed in the last 100 days, just so that we can see where the facts really are with her substance abuse so that she can get the right access to services. I know that she's been using, she's testified to that, but I'd like to make sure that she's getting the right treatment and that she is able to be honest with what she needs with her treatment provider so that she can do differently this time and be successful. I would agree that while mom is in inpatient, twice a month visits supervised by the department would be appropriate while she's getting treatment. The minute she is successfully discharged from treatment, CASA would like to reevaluate that and also consider what possibilities the caregivers would be willing to supervise in addition to the department supervising visits. But I do agree that this child needs legal permanency. He's only 2 and all of his life sounds like it's been very inconsistent and unstable, and he needs that.
Thank you, Ms. Harding. Mr. McKeska, any rebuttal?
Judge, just with regard to the claim that the department hasn't met its burden for immediate danger, is the court's aware there is no definition of immediate danger in the family code. So I think that the court can look to other sources of authority in making its decision today. And there's volumes of authority under section 161.001 B1 D and E regarding the endangerment grounds and the ability to terminate a parent's rights based on endangerment. And courts have upheld a life of uncertainty, right, and instability does rise to the level of endangerment under those grounds in which a court can terminate a parent's rights. We're not asking for that today, but I just think that the court can look to other sources of authority in making the determination that there is in fact an immediate danger to this child today if he will return to Ms. Gallimore's care.
Thank you, Mr. McKesker. Can you, Mr. McKesker, remind me one more time the specific agreement as to visitation with the father and how that's going to be practically handled?
Judge, the agreement was that if he's determined to the father and upon his release, then it would be 1 time a week for an hour supervised by the department.
Just making sure I understood that. After hearing the evidence and arguments of counsel, the court finds it has jurisdiction over this suit. Court finds that Mr. Rodriguez was served and that Ms. Gallimore has, I don't know if she was served, but I do know that she has appeared here today, participated in this hearing with counsel. So she's made a general appearance. Mr. McKesker, was she served personally?
Judge, I know Ms. Gallimore's testimony was that she was. I do not have a return of service in the file.
Okay. Well, I'll find that she's made a general appearance. We also have an unknown father in this case, and I think the department and the parties have addressed that sufficiently today as far as ordering and agreeing to a DNA test for Mr. Rodriguez to find out whether or not, excuse me, he is the actual father of the child. Based on the evidence here today, court finds that there's sufficient evidence to satisfy a person of ordinary prudence and caution that there was a danger to the physical health or safety of the child caused by an act or failure to act of the person entitled to possession, and for the child to remain in the home is contrary to the welfare of the child. The urgent need for protection required the immediate removal of the child, and reasonable efforts consistent with the circumstances and providing for the safety of the child were made to eliminate or prevent the child's removal. And reasonable efforts have been made to enable the child to return home, but there's a substantial risk of continuing danger if the child is returned home. Heard a lot of evidence, and I do agree that the one thing that was kind of rattling around in my mind was not only have I been involved with this family for a while, but if in fact you were to go with the argument that the child hasn't been moved, and let's say that you assume that Miss Gallimore wasn't going to go pick the child up, this is no way for this child to live without a road or a path to permanency involving both of the child's parents. And Mr. McKesker is correct that if we can terminate rights based on instability under D&E, and there is a very large amount of authority to support that, then we can certainly enter into temporary orders that fall under the prong of it being contrary to the welfare of the child. We don't know what Ms. Gallimore is going to do. I certainly hope that she stays in rehab. I've told her this before, that if not for her child, for herself, for her own life. That's why I made the order that I made in the previous case. I want to see you clean, Ms. Gallimore, and I want to see you able to think clearly and parent your child. That's what needs to happen here. And we couldn't get it done in a court-ordered services case, so we're getting it done in a conservatorship case, which I told you was the next step. I was very blunt with you about that. So here we are, and it's happening. Now, I'm also going to tell you that once the department takes temporary managing conservatorship of your child, which is I am awarding them that today, the next step is that you've got to do these services or your rights could be terminated. Didn't listen to me the first time. I hope you listen to me the second time when I'm telling you that this is going to happen if you do not comply with the court's orders. I'm going to approve the agreement of the parties as to the father. Temporary managing conservatorship, he's a possessory conservator. Complete the genetic testing, and if he's adjudicated, we'll waive medical support and child support, develop a family plan of service at a family group conference, and he'll have visitation once a week upon release, supervised by the department. And I'm going to make those same orders compulsory for the mother as they apply to her. She'll be a temporary possessory conservator. The department will be temporary managing conservator. She'll have a family group conference, develop a family plan of service. But as far as the visitation is concerned, because we have a drug issue, I'm going to order that she have a hair follicle drug test by Friday with no altering of her hair. That's 5 p.m. So don't do anything to your hair. You're there in a rehab facility. You shouldn't be doing drugs or altering your hair anyways, but I want something today, or excuse me, by Friday, that shows where we are with this case. If mom stays in rehab, continues to engage in her services, does what she's supposed to do, I agree with Mr. McKeska. We're going to start it once every 2 weeks, so twice a month. But if she's engaged and she's doing what she's supposed to do, and you're getting good reports from the facility, then you all are authorized to increase that. So, Ms. Gallimore, how much? I keep hearing a click, and I don't know where it's coming from. Ms. Gallimore, if you stay engaged and you do what you're supposed to do, then you are going to get more time with your child. It's not punitive. I'm not saying you can't have time with your child because I want to punish you. I'm concerned about your stability, and I'm concerned about your ability to be around your child and to be a good influence on your child. I've noticed today that when it comes to dates, times, things like that involve allegations against you, your memory gets very fuzzy. But when it comes to dates, times, and allegations that have no impact on you, you can remember everything. So you need to be aware of the fact that I want you to be a good influence on your child, and I don't think you're going to get there right now, because you're still, you just used the night, last night or the night before, whatever that was, over the weekend. We've got to get you clean. Court finds that the placement of the child with the grandparents is safe, appropriate, meeting the needs of the child and the child's best interest to continue. As if I haven't said it, I am granting the Department of Family Protective Services /belong temporary managing conservatorship of the child. I'll find, for the purposes of this hearing, in this case, that Mr. Rodriguez remains incarcerated and Miss Gallimore is in a treatment facility. And so I will maintain their indigency status and continue the appointment of Miss Mance and Miss Fuller to represent the parents, respectively. We're going to have a status hearing April 10th, 2024 at 9:30. April 10th, 2024 at 9:30. I have to admonish Ms. Gallimore and Mr. Rodriguez that the state of Texas gives parents in CPS cases 12 months to demonstrate that you can provide a safe, stable, violence, and drug-free home for your child. If you cannot demonstrate that within the 12 months, your rights are subject to further restriction, as they are restricted now, or termination. It's time to get some work done, get off on the right foot, do what you can in between now and the status hearing. I don't want to come back on April the 10th and find out, Ms. Gallimore, that you're not in rehab anymore, or that you haven't been keeping in touch with Ms. Rabago or whoever it is your caseworker is going to be. I want to find out that you've hit the ground running and that you're doing everything you can to get clean and that you're doing everything you can to be reunified with your child. Okay? Bryson deserves it. Mr. McKeska, is there anything I failed to address?
No, Judge, we covered it all.
Okay. Well, good luck to you, parents. Thank you all parties for your time and your service, and the advocates. I appreciate it. And if nothing further, all parties are excused, and I'll see some of you after lunch.
I love you.
John Dozel for the department. Thank you.
Belong permanency specialist.
Lindsay Liggett, belong permanency supervisor.
Richard Saldivar, attorney for the child, ready?
Amy Harding, Hill Country Casa supervisor, guardian ad litem for the child.
Annette Lucas, Hill Country Casa, guardian ad litem for the child.
Lucinda Mance for the mother, Melissa Gallimore, and she is present.
Deborah Fuller for the alleged father, Kevin Rodriguez, and he's present already, Your Honor. Although I did not receive a status report for today. So if someone could send me that.
Ms. Gallimore, did you already announce?
I'm here.
I need you to state your name.
Melissa Gallimore, I'm here.
Thank you.
Yes, sir.
All right,
Kevin
Mr. Rodriguez,
Rodriguez.
you can go ahead and announce.
This is Kevin Rodriguez. I'm here.
All right, Mr. Rodriguez, I was getting some background noise a moment ago, so I'm going to put you back on mute until we need you, okay? We're here for a status hearing today. And I'm looking at the status report for Bryson. There you are, Miss Lewis. I couldn't find you on the screen. Bryson is 2 and placed in a kinship placement in Kendall County at this time. Is that correct?
Yes, it is.
And is that placement safe and appropriate, meeting his needs?
Yes, it is.
Is it in his best interest to remain in that placement at this time?
Yes.
All right. Since our last hearing, have there been any other family members that have come forward or any other placements identified?
Not at this time.
And is this the least restrictive placement available?
Yes.
Okay. And Bryson's up to date on all of his checkups.
Yes, he is.
Any concerns with this cavity that he's got?
I don't believe so. I know the grandparents will be treating that, and he's also getting a ECI evaluation on the 11th.
Does he exhibit any developmental issues, or is he just getting the standard evaluation?
I think just getting the standard evaluation.
Any other concerns with Bryson or the placement at this time?
No.
Okay. And then let's talk about the parents. Are the parents cooperating with you?
Yes.
Are they communicating with you, returning your, I know it's probably different from Mr. Rodriguez, but you're getting calls back and you're getting your questions answered?
Yes, I am.
All right. Did one or both the parents participate in a family group conference?
Yes, Miss Gallimore was able to. I don't believe Mr. Rodriguez was due to his incarceration.
Okay. And did Miss Gallimore participate in the creation of her family plan of service?
Yes.
Did she have a chance to review it and sign it?
She, 1 second. I know we did review it. And we were not able to see her in person, sadly, due to where she's at, but we were able to go over it with her, and I don't believe she has signed it yet, but I will double check on that. I apologize.
Okay. And when you said where she's at, where is she?
Oh, she has signed it. I apologize.
Okay.
She is at Ripple Ranch. It's an inpatient center in Spring Branch area.
And Mr. Rodriguez, has he had a chance to review the family plan of service that was created?
He has not, but we have a courtesy worker going out to see him this week as well. So she's going to take it out to him and review it with him.
There's no Indian child heritage in this case, correct?
No.
Okay. Do you believe that the family plans of service that were created are narrowly tailored to address the concerns that brought Bryson into the care of the belong in the department?
Yes.
And do you believe that the family plans of service are in the best interest of Bryson?
Yes.
Are you asking the court to make those family plans of service orders today?
Yes.
And were they filed?
Yes, they were.
Do you believe that either parent has fully addressed the concerns that brought Bryson into the care of belong?
Not at this time.
And as of today, would it be safe to return the child to either parent?
Not at this time.
And you believe it's in Bryson's best interest to remain in the temporary managing conservatorship of the department?
Yes.
Mr. McKeska, no, Mr. Dolezal. See how you said that I am? It just wrote. Mr.
I
Dolezal.
understand the problem, Your Honor.
Do you have any questions?
Yes, just a couple. Ms. Lewis, have you had an opportunity to talk with Mr. Rodriguez at all?
I believe that the worker that is helping me on this case reached out, but I don't believe that she's been able to have contact with him yet.
All right, he's listed as an alleged father. Do you know if he's made any statement as to his paternity or him being the father of Bryce?
I do not.
Okay. I'll pass the witness, Your Honor.
Ms. Smantz?
Yes, if the mother is requesting that she be hair follicle tested every 90 days, will the department cooperate with that?
Yes.
And do you know the status of any DNA test?
I do not, but I will follow up on that.
All right, thank you. I'll pass, Judge.
Ms. Fuller?
Ms. Lewis, can you provide my office with a copy of the plan of service
Absolutely.
and the status report for today?
Yes.
And in regards to the courtesy worker, has she met with my client at all?
I do not believe so. We were going to go out and see him when he was still in Bexar County, and when we called, he had just been transferred. So she's going out tomorrow.
Okay, and did the caseworker provide the location information to their attorney for the DNA testing?
Yes.
Okay, because originally he had said he was going to be at the Dominguez unit, but now he's at Garza West.
Yes, I will double check on that, but I believe we do.
Okay. And what services are you asking Mr. Rodriguez to do?
Yes, we are asking him to engage in just finding a proof of employment and a stable housing, along with parenting classes, a substance abuse and drug and alcohol assessment, random drug testing, a psychosocial assessment and individual counseling, and domestic violence classes.
And have you determined whether any of those services are available at the Garza West unit?
I have not, but I'm hopeful that we will find out more tomorrow so we can get him in any of those services.
Okay, and you are not going to be visiting with him, correct? Only a courtesy worker.
Yes, but we have spoken with her and updated her.
Okay. Pass the witness, Your Honor.
Mr. Saldivar?
Yes, Bryson's doing well at his current placement with his grandparents. Is that correct?
Yes.
Any concerns for his health or well-being?
No, he's doing really good. He's a happy 2-year-old.
Perfect. Okay. And the grandmother currently is working. Is that correct?
Yes, she does.
And so it's grandpa that primarily cares for Bryson. Is that correct?
Yes.
Have the grandparents discussed daycare with you at all?
They have. I do know that the grandfather is looking into going back to work. He just retired but wants to go back. Bryson right now is in, I believe, a Head Start program, but Head Start gets out at, I believe, 3 p.m. and he would have to work later than that. So he was looking into a possible daycare that stays open later.
Okay. So it's possible that they may need help with daycare. Is that correct?
Yes. Yes.
Okay. And do you believe that the daycare would benefit Bryson with the socialization of the other children?
Absolutely.
Okay. Does Bryson need any orders from the support here today?
Not at this time, just possible daycare help.
Okay. And as far as visits with the parents, has he been visiting with mom?
Yes. He has
And
Zoom calls.
Zoom calls. Okay. And how is that going?
They're good. They have fun.
Okay. And he is bonding with his mother. Is that correct?
Yes.
Okay. Are you looking to keep the visitation the same at this time or modify it in any way?
At this time, just keep it the same.
Same. Okay. And since the father's incarcerated, has he had any visitation with the child?
He has not.
Okay. Is he able to write letters or do anything of that nature with the child?
I can definitely ask tomorrow and see if we can get some letters.
Okay. Pass the witness, Judge. Thank you.
Any follow-up from anybody else?
Yes, Your Honor. I just ask Ms. Lewis what services mom's been asked to do or told to do.
She has been asked to also have proof of employment and stable housing, along with parenting classes, a substance abuse inpatient treatment center, individual counseling. Sorry. Along with random drug testing and not inpatient, BIP classes.
I have nothing further, Your Honor.
Anyone else?
I have a quick question.
Go ahead.
Yes, Ms. Lewis, mom is currently at Ripple Ranch, but she will be transitioning to a treatment center in Bexar County through Haven for Hope. Will you modify her visitation that's upon her release from Ripple House?
Yes.
All right, thank you.
Anybody else have any other witnesses?
Department rests.
No witnesses, Your Honor.
No witnesses, Your
Honor. Before I hear from the ad items, any other argument?
No, Your Honor.
No, Your Honor.
Then, Mr. Saldivar, what are your thoughts?
Judge, Bryson's doing well with the grandparents. I have no concerns. They're meeting all his needs. Once mom transitions to Bexar County, I don't oppose the modification of the visits. I believe he enjoys the visits with his mother. Judge, I am asking you to order daycare for Bryson. Grandfather needs to go back to work, and that would help. Grandmother works full time, and I believe that would also help him socialize. He has a lot of energy, Judge, and so that would be in his best interest to order that here today. Other than that, Judge, I have no other concerns.
Ms. Lucas?
Well, I just was given the case, and so I'm going to cede to Amy because she knows the background, and I have not met with the family yet. I do know the case background and the information, so next time I will be able to do my report. But I'm going to start a visit with the family next week, and so I'll let Amy go ahead.
Okay. Thank you.
Your Honor, I had an opportunity to visit the grandparents and the child in their home. I was there for several hours. I am concerned about Bryson's limited speech at his age. He does not have a lot of words, and I was in the home for quite some time. So I'm thankful that the ECI evaluation is happening tomorrow. It will not surprise me if some speech therapy is ordered for him. He does have a lot of energy, and I think that for his socialization and speech development, daycare would be a necessity for him. Additionally, the Head Start program that he's currently in is through the school year, so childcare is going to be an issue during the summer, especially if the grandfather returns to work. But I think for his speech and socialization, daycare needs to be provided. CASA is not opposed to a modification to the visitation schedule once mom successfully completes her current treatment program, and would really like the opportunity for parties in this case to modify visitation based on the parent's compliance and progress in services, so that we can move things forward when appropriate without returning to court. And we certainly want to see DNA testing completed as soon as possible.
Thank you. I think everything else that I read in the CASA report and the recommendations we've talked about are addressed today. So, I've made a note of it in my ruling. So, with that, for the purposes of the status hearing, court finds there's no Indian child heritage in this suit. Both parents are cooperating. That Bryson is placed with a relative in Kendall County, and that placement is safe, appropriate, meeting his needs, and in his best interest to continue. And that placement is the least restrictive placement available. Court finds Bryson is up to date on all of his checkups, and that his dental concern is being addressed, and that he will have an ECI evaluation as well. Court finds that it is in his best interest to order that daycare, not only so grandparents can work, but also so Bryson can get the socialization and then the help with his speech that he needs through that as well. Court finds that the current visitation plan with the mother is appropriate. However, I am going to authorize the parties to increase it as you all can agree and see fit based on progress in this case. Court finds that the parties held a family group conference, that Ms. Gallimore participated in the family group conference. She participated in the creation of a family plan of service. She has reviewed it and signed it. Court finds that Mr. Rodriguez, due to his incarceration, did not participate, and that he has not reviewed it or signed it yet, but that it will be occurring soon. Court takes judicial notice that the family plans of service are on file. The court finds that the family plans of service are in the best interest of the child and will be made orders of the court, subject to any issues that may come up with Mr. Rodriguez. Always when we have incarcerated parents, it might be able to change the plan up a little bit. I always want to keep it in mind that it's something we might be able to adjust to. Court finds that mom is currently in inpatient rehab. Ms. Gallimore, I'm extremely proud of you for doing that.
Thank you.
I am too. Good. You should be. And I hope that you stick with everything, that you stay there, and that when you get out, you do your aftercare and you see the difference. I can already see the difference in you sitting here today. So I'm very proud of you for that.
Thank you.
Court does have to make a finding that as of today, it's not safe to return the child to either parent, and that as of today, neither parent has fully addressed the concerns, but I'm very pleased to see where we are as of the status hearing. Our next hearing is going to be our initial permanency hearing, August the 14th, 2024 at 10 a.m. August 14th, 2024 at 10 a.m. That's going to put us right around halfway through the case. So hopefully, Ms. Gallimore, by that time, you'll have made some substantial progress, and we can start looking to the future here. I do have to admonish the parents. The state of Texas gives parents in CPS cases 12 months to demonstrate you can provide a safe, stable, violence, and drug-free home for your child. If you cannot do so, your rights to your child are subject to further restriction as they are now, or termination. Anything I have failed to address? The DNA test. I want to make sure that gets done. I already ordered it, but we need to make sure we stay on top of that. Okay. Do we need any further orders as to the DNA test?
I don't think so, Your Honor. He was moved to a different facility. That he was told he was going to go to Dominguez, and that's what we let them know at the temporary orders hearing, but he was moved to Garza West. So he'll be there till at least June is my understanding. So hopefully they can do it there.
Okay. Anything from anyone else?
No, Your Honor.
No, Your Honor.
Well, thank you all for your time and your service. Ms. Gallimore, again, I'm proud of you. Good luck. Keep working hard.
I have a question.
Is it a legal question or is it?
Yeah, well, I was wondering if I was gonna get the 90 days, every 90 days for the hair follicle.
Do you have any issue with that, Ms. Lewis?
No.
Isn't it 105? Is it 90 or is it 105?
I believe it just varies, but I don't have an issue with doing that.
Then we can put that in the order, Mr. Dolezal, that
I will. Thank you, Your Honor.
All right. Okay. Thank you all for your time and your service. If nothing further, all parties are excused.
Thank you, Judge.
You're welcome.
Thank you.
Oh my goodness.
Hi, baby.
Hey.
Please, no communication. We are in a court hearing.
Yeah, so I put mute on so they can't hear me right now, but
You're muted. I can't hear you.
Ms. Jennings, Mr. Herndon, this is a court of law. Please stop communicating.
Fuller. Mr. McKeska, would you please begin the announcements?
Thank you, Judge. Drake McKeska, attorney for the department. Ms. Rios?
Kimberly Rios, family-based caseworker. Carol McKetta, family-based supervisor.
Anna Swallow, attorney ad litem for the respondent mother, Julie Jennings. Ms. Jennings, could you please state your name?
Julianne Jennings.
Maureen Yanis, attorney ad litem for father, Cameron Hendon. Mr. Hendon, will you unmute and announce, please?
Yeah, I'm here. Cameron Hendon.
Deborah Fuller, attorney ad litem, standing in for Jennifer Harris, representing the child.
Mr. McKeska, how are we proceeding today?
Judge, we were able to confirm and reach an agreement for the court-ordered services.
All right. Anything specific?
Judge, the department's requesting the parents be ordered to complete a drug and alcohol assessment and follow any and all recommendations from that assessment. For the parents to complete random drug testing to include oral swabs, UAs, and hair strand testing. The parents to attend individual therapy. Then for the parents to sign any and all necessary releases of information for the department to be able to communicate with the service providers. For the parents to follow the safety plans that are created in this case, for the child to be immediately evaluated by a medical professional, and for the child to be seen specifically for drug testing to determine whether or not she has enough hair to complete the test. And I know usually in all of our cases, Judge, whenever we do request that testing, that the testing for the child be completed by a medical professional for medical purposes. There is concern she may have been exposed to controlled substances. And then in addition to that, the department has requested Mr. Hendon to submit to a UA and hair strand test today.
Ms. Swallow, is that your understanding of the agreement?
As to my client, yes, Judge.
Ms. Yanis?
Yes, Judge.
And Ms. Fuller?
Yes, Your Honor.
Ms. Jennings, is that your understanding of the agreement?
Yes. Yes, sir. Yes, Your Honor.
Is that the agreement you made?
Yes, sir.
Did you have an opportunity to discuss it with your attorney?
Not about the baby having the hair follicle, but about the services and what they were asking of my husband. Yes. So no, I was not told about the baby being given any kind of evaluation for her hair.
Do you object to it?
I kind of do, yeah, only because she's a baby. I mean, I don't understand all that. Being evaluated, to see if she's got any problems is one thing, but, she has no hair really. So,
All right. Well, Ms. Swallow, do you feel like you need to talk to her about that?
Yes, I do.
Okay. I'm going to put you in a breakout room for about 60 seconds because I've got to get moving with this next case. It's after the two of you, or after this one. I'm putting you all back in room 3. Did you have a chance to discuss the child's testing with your client, Ms. Swallow?
Yes, Judge, we're in agreement.
Okay. Mr. Hendon, you heard the agreement that was announced?
Yes,
Is that the agreement you made?
I made the agreement to do any drug evaluation for myself. Yeah, I'll do anything y'all need. I don't want to jeopardize and losing my daughter.
Did you discuss this agreement with your attorney?
I did, Miss Maureen. Yeah, very nice lady.
Do you understand what's expected of you?
Yeah, I do.
Are you asking the court to approve your agreement today?
Yeah, really. Yeah. Yes, sir, Your Honor.
All right, thank you. Miss Fuller, is there anything that you wanted to add on behalf of Miss Harris?
Well, Ms. Harris is really concerned about the facts of the case and it not being a removal. I will say that, but she is also concerned that the mother's still married to Ben Holloman, is my understanding. So Mr. Hendon is not the presumed father, like the affidavit says. So that's the concerns that she has.
Don't talk while the attorneys are talking, please. Go ahead.
That she has, and she wants to make sure that any contact is by the mother is supervised when she gets out of jail.
Okay. Well, and is that the safety plan that you all have discussed?
No, Judge.
Your Honor, if I may.
Ms. Rios, you have something to add?
Just that there is a safety plan in place and the department does plan on including Ms. Jennings to that if and when she's released.
Okay. All right. Anything further from anyone else?
If I could just have a copy of the safety plan.
Yes, ma'am.
Thank you.
I can provide this to all the attorneys today.
All right. Then based on the agreement of the parties, court finds that Ms. Jennings and Mr. Hendon have both appeared today. I don't know if they were served, but either way, they've made an appearance today, a general appearance. And
yeah, Rod Chalmers came by.
Okay, Mr. Hendon, you cannot speak when I'm speaking or giving an order. Okay?
All right.
Court finds that they both entered a general appearance. Court finds that the parties have an agreement for court-ordered services, and the agreement for court-ordered services includes drug and alcohol assessment and following all recommendations, random drug testing to include oral swabs, UAs, and hair strand tests. Parties are to attend individual therapy, sign releases for information, and follow the safety plan in this case. Court also orders the child to be immediately evaluated by a medical professional. Keep on mute, Mr. Hendon. I'm getting a lot of noise from you. To be seen for drug testing to determine whether there's enough hair to complete a drug test, and for that test to be done by a medical professional. The department is to submit to, the father is to submit to a UA and hair strand test today. 2:10, I want that done by 5 o'clock. Don't do anything to your hair, Mr. Hendon. Don't alter it in any way. Mr. McKeska, I left anything off that agreement?
No, Judge, I believe you covered it all.
Judge, I would just request that Mr. Hendon be with his child, that when they take her, when they wanted to, that he takes her to the facility, that he's there, that no one takes the child and does that.
Thank you. Thank you, Ms. Lau.
Okay.
And Your Honor, he's not even the presumed father.
Just a minute. I need Ms. Jennings and Mr. Hendon to understand something. This is not a business meeting. This is a court of law. The only time you speak is when somebody's speaking to you or asking you a question. Okay? I want you to keep your channel on mute, and you only talk when somebody addresses you directly. And that I want you to remember that for the next hearing, because it's very disorganized and it's very distracting for me when you two are talking whenever it feels like it's appropriate for you to talk. It's not, unless you're being addressed. All right. Mr. McKeska, Ms. Fuller, and Ms. Yanis, any issue with the father being present with the child?
No, Judge.
No, Judge.
Okay. Then I'll make that part of the order, that he is there with the child. All right, as far as the required participation, court finds that these orders are necessary to alleviate the effects of abuse or neglect that has occurred, to reduce the continuing danger to the physical health or safety of a child caused by an act or failure to act of the parents, and to reduce a substantial risk of abuse or neglect caused by an act or failure to act of the parents. Court finds that there are facts sufficient in this case to support a finding that the child has been a victim of abuse or neglect, or is at substantial risk of abuse or neglect, and that there's a continuing danger to the physical health or safety of the child caused by an act or failure to act of the parent. Court finds that these orders are in the best interest of the child. We'll be back for our compliance hearing on May 10th, 2024 at 2:30. That's May 10th, 2024 at 2:30. I want to make sure, Mr. Hennon and Ms. Jennings, that you understand something. I just had to, in a case earlier today, order the emergency removal of a child because the parents didn't cooperate in their court-ordered services case. They didn't listen to me. They didn't obey my orders. They didn't pay attention to things. Hey, Mr. Hennon, don't speak unless I give you the opportunity to speak.
I was going to ask you a question, but I'll wait till you're done.
Hang on. You're going to wait. You're not going to ask me your question yet because I'm talking. I want to make sure you understand that if you don't follow the orders in this case, something more serious could happen and your child could be removed from you legally. Okay, so this is a very non-invasive way for you to maintain contact with your child, for there to be no legal changes to conservatorship, and for you to get services provided to you paid for by the state of Texas. If you don't do it, then something more stringent can happen. I'm running over time. I'm at 2:14. I'm supposed to have started another hearing at 2. So, Mr. Hennon, I'm going to let you talk to your attorney about any questions that you have. I've made my order. Good luck to you, parents. I'll see you all May 10th at 2:30. Nothing further. All parties are excused.
Thank you.
We're almost done. Are you all missing anybody that you expected to see on screen for this case?
No, Judge, I didn't expect the mother to be here. I don't believe she is present. She, at least based off what we have in our file at this time, has not been served.
Okay. When would you like to reset to?
The next available date that Emily Kyler Green can cover.
Yeah, Your Honor, they haven't been able to find the child and the mother, and so I haven't had an opportunity to even see my client because they haven't been able to locate them.
So, Ms. Fuller, we actually do know where your client is. They are lying to law enforcement when they show up at the house to serve them. We have somebody from inside the home texting us saying they're currently here, and the partner of the mother saying that she left to go to Oklahoma. And so Miss Mayhew has an active warrant and no longer has a phone of her own. All her communications have to go through this partner, which is part of our concern. And so we can definitely provide you that number. I just don't know that it would be successful for you either, which is obviously part of why we're here for a motion to participate.
Thank you, Ms. Vanderbilt, for the information.
Well, we have a Medina date next week. We don't have anything set on it, but our next Medina date after that is not until the 9th.
So court will reset the court-ordered services case to March 28th, 2024 at 9 a.m. by Zoom. Any questions?
No,
Judge.
Okay, then all parties are excused. Ms. Vanderbilt, will you hang out just for a second, please?
Yes, sir.
All right, thank you, Judge.
You're welcome. Thank you.
Thank
you.